It being 7:02 and want to take good advantage of everyone's time. I'd like to call our meeting to order and to the planning board meeting on, pardon me, April 9th. And so let's do a quick roll call vote as I see you. Matt Lowry,
Here.
Jim Hogan,
Here.
Kevin York,
Here.
and myself, Theo Knoll, here. So we have our quorum, and our second item is approval of the minutes from March 26th. Does anybody have any questions, comments, additions or deletions? Otherwise, is there a motion?
I'll make a motion to approve the minutes as presented.
All right. Thank you, Matt. Is there a second?
Second.
Thank you, Kevin. All right. All in favor? Matt Lowry,
Yes.
Jim Hogan,
Yes.
Kevin York,
Yes.
and myself, yes. So Theo Knoll, so 4-0. All right. That's terrific. So our third item of business is to open the public hearing on the.
Oh, I didn't know somebody was on.
Yeah. Thank you, everybody, for muting. We want to open the public hearing on the citizens' petition regarding the MBTA 3A Communities Overlay District. This is our primary business tonight, and we've been. I think the town has really been having a valuable discussion about this issue and the opportunities, and it is a really important discussion, and it's really vital to have an informed discussion about MBTA communities and the petition. This is not an us versus them discussion either. What I find so engaging and rewarding is that we are each friends and neighbors, residents and business owners with the shared goals for a vibrant, livable, welcoming, and inclusive community that we know and enjoy. And I do also want to say that all of us attending the meeting, are, as town residents, really are committed to this public process and our town meeting form of government. So tonight we're here to learn about the petition, enable all of us to question and learn so that we can bring this information with us so we can make informed decisions at town meeting. And just as way of introduction, I really do want to thank all the members of the working group and everyone who's volunteered on this research over the past year for your dedication, your energy, and intellect evaluating what MBTA communities is and how it works. And I really also want to welcome Councilor Dombrowski and thank him for his attention as well. At this time, this is the only scheduled public hearing the planning board has scheduled and can have, given the timing of the petition, town elections on April 23rd, which would have been our next board meeting time, and the upcoming town meeting on Monday, April 29th. And the last housekeeping, when you want to speak, we really do ask that you turn your camera on, state your address, and everyone's got up to 5 minutes per open meeting law requirements. I'll keep time and ask Jim Hogan to help manage the discussion and keep track of everybody. And with that, I'll also welcome Bill Spalding to the meeting. So, Councilor Dombrowski,
Mr. Chair, if I may, just the one piece of housekeeping. Just want to make sure that we're clear with all the members who are on, of the public who are on, that tonight we are not taking a vote to make any decisions as it relates to if the zoning will be passed or not. The purpose of tonight's public hearing is solely for the purpose of the planning board to solicit feedback from the public on the citizen petition and vote whether or not the planning board will make a recommendation to town meeting, whether or not that this should have favorable action or not favorable action. But to be clear for all parties involved, this meeting will result in basically a recommendation by the planning board to town meeting and that town meeting ultimately will be the forum for which this zoning would either be passed or not passed.
Thank you, Jim. That's a really important clarification and a reminder for tonight and town meeting, right? All the decisions happen at town meeting. So Councillor Dombrowski, we'd like to invite you to present your citizens petition. And I'd like to turn it over to you.
Thank you, very much, Mr. Chairman, and thank you, board, for taking the time. I'll share my screen now. Is everyone able to see that?
Yes.
Okay. So, good evening. I am before you tonight to present this drafted article. It's Article 18 that appears on the town warrant and will be part of our spring town meeting beginning on the 29th of April. And this petition, the citizen petition drafted article, it relates to the MBTA communities, and as we all know, it Chapter 40A, Section 3A. And I understand that this body certainly is well versed in that new law, but for the benefit of those who may not be, those watching or otherwise in attendance this evening, I just wanted to go through just a very basic overview, if I could, just to reorient everyone. So as far as the background, what is an MBTA community? It's defined by this law as one of 14 cities and towns that initially hosted the MBTA service, one of 51 cities and towns that also host MBTA service, but joined later. Other served communities that abut a city or town hosting MBTA service, or a municipality that's been added by statute. In total, the state is reporting that 177 cities and towns of the 351 communities across the Commonwealth have been identified as MBTA communities. There are basically 4 different categories that these communities fall under: either rapid transit, commuter rail, adjacent community or small town, and adjacent small town. For context, I am presenting this map that the state has identified, indicating the variety of community identifiers, if you will, showing that it is a mix of many different transit types that connect with each of the cities and towns. Specifically, MBTA communities focuses on multifamily, and we are required as one of the 177 communities that's part of this to be compliant with all of the rules and regulations by December 31st of 2024, so the end of this calendar year. I appreciate the foresight that this planning board has had, recognizing that we have town meeting in spring and obviously town meeting in fall in the event there is any additional work to be done. I'll also point out that versus a lot of our other peer communities, we as a town are well ahead of working through these issues. And I think that's a great credit to our community as a whole. And I do appreciate the work that the working group has done, having since their formation last spring, and obviously the work of this body as well relative to that. The specifics of Section 3A talk about the fact that we have to create at least one zoning district of reasonable size in which multifamily housing is permitted as a matter of right. And I think that terminology is actually quite important here. And from my engagement with constituents, that is language that is concerning, and I think rightfully so. To be clear, I do not think that this law, which presents as a one-size-fits-all approach to addressing the issues of housing within our Commonwealth, is the right step. I know that there's been a lot of pushback, not just within our own community, but across the Commonwealth by those communities who have been impacted by it. And obviously 177 represents a very significant portion of of our Commonwealth, but also represents a significant portion of our total population, because most of the identified MBTA communities have population, greater density, greater population than some of the other communities that may not fall under this criteria. So I can understand that it is law that impacts a lot of people in a lot of communities. And as we all know, there have been various reactions to it. I think one of them we're all probably aware of is in Milton. A bit different designation in Milton, but they are now facing litigation by the Attorney General's office for failure to comply. Their compliance date was earlier than ours is, and the Attorney General's office has made clear that they are going to move forward with litigation, arguments to be heard before the Supreme Judicial Court next month. As I point out here, though, for our purposes, failure to comply with this new law would result in a loss of eligibility for certain state funding and potential litigation. I've touched on the litigation, and the state funding piece is also significant. In my capacity as a town councilor over the last 7 years, I've really seen a shift in recent years by the state, and especially in the last couple of budget cycles, whereby more state funding is coming in the form of grants as compared with local aid. And so you hear about Chapter 70 funding, which relates to schools, or Chapter 90 funding relating to roads. A lot more dollars are coming to our communities via grants. And so when we look at our history of receiving state dollars as a community in Wakefield, and what we would set to lose if we were no longer eligible for those, I don't think it's reasonable to take the position that we can just not comply. And I know that some people have that position, and I respect the passion with which they assert that position. And I also can understand the frustration that brings them to that conclusion. But I can say that in my elected capacity, I think it'd be irresponsible of me or other town leaders to take the position that we can forego the significant state funding. And I went through and looked at the numbers, and we're talking millions of dollars that we've received just in recent budget cycles from the state. Those dollars have paid for any number of meaningful projects, and those dollars would have to be replaced candidly if we didn't have that funding source through the local tax base. And that's just too heavy a burden for the taxpayers to bear. And so I think that's just not realistic. As I had mentioned, that this is a one-size-fits-all requirement. The state has indicated that they're looking to work with cities and towns that are affected, although it's not very clear how that looks currently. If you think of this as a carrot and stick approach, thus far, the state's approach has been far more stick than carrot. And with respect to the specifics of what that means in terms of density, we're talking minimum gross density of 15 units per acre, which I know that this body is familiar with, located not more than a half mile radius from public transit. In our case, that would be around the commuter rail station. Notably, no age restrictions, and it must be suitable for families with children. What strikes me with that aspect of it, and what a lot of constituents have raised, is that has created the inability to focus on senior housing, which is because of the no age restrictions mandates. Senior housing is a significant issue for our community, especially as our population ages, but it's not considered, in fact, it's prohibited under this legislation that's been enacted. The other piece to this is as a matter of right. And I think that probably gets to one of the central concerns that I have heard from a number of constituents, and one that I share as well. As a matter of right means that we lose our local control. We have the benefit right now, if you will, of being able to have a zoning board of appeals, having a planning board that is able to help to set the course of what development in our town looks like. And when I think about the ZBA in particular, there are a lot of projects that have been enhanced and improved because of the work that we're able to do at the local level, because we know at the local level what best works for our own community. So the loss of that autonomy is significant. I also point out that this law fails to address the issue of affordability in a meaningful way. The thinking obviously is, well, if you add supply, then ultimately that will drive down cost. When you look at that from a supply, versus demand perspective, we'd be looking at decades before we'd see anything discernible in that way. What it will end up doing is adding some amount of inventory or stock to our housing availability, but it does not mean that by any means will be affordable. And I think that there are good cases in point within our own community to demonstrate that. So I next show you what I worked up as a comparison. As we know, the working group spent a good amount of time, looked at several different sites for where to create this zone or this district, if you will. I know that Greenwood was considered, different parts of where you ultimately, or where the working group ultimately ended up landing, and I know it wasn't haphazardly done. I think what's important about this article, which is an amendment to what has been proposed by the working group and advanced by this board, is looking at the sheer numbers. As we all know, the requirements in order to be within compliance of 3A is a capacity of 1,696 units within the district. By the working group's computations, we're already at 1,641 multifamily unit capacity. So we're talking about a deficit of 55 units, or what we're looking at in terms of an increase that would be required. I think this chart is demonstrative of where we can be and where the working group has proposed we be. Now, the working group, based upon its article number 17 on the warrant, proposes a district that would, in essence, create the potential for 2,359 multifamily units, or 663 more than would be required by law, based upon the calculations. So, in essence, we're talking about 13 times the number that would be required in order for us to get to, we're talking about 13 times more than what's required of us as a matter of obligation as the law provides. And I think that's significant. And I would say that those with whom I've spoken, those that I've heard speak before this board, and those that I've heard speak with the working group, have been very clear that their concern lies in this idea of going above and beyond the 1,696. Now, in practical terms, what does that mean? It means that we lose control. It means that as a community, we are ceding control of development decisions to developers. And we're ceding control in a significant way. To be compliant, we have to be able to have this accommodation of 55 additional. To extend beyond it means that we're losing control of 663. Again, I think the 39% more than required is telling. That's a significant percentage. And I look at this through the lens of what I hear a lot with 40B projects. Again, I've done plenty of site visits where the developer and attorneys and residents have been present to talk about those, as well as many town officials. Time and time and time again, one of the recurring themes that I hear from those that are concerned about our 40B is, why are we not at 10%? And we keep hearing our goal is to achieve 10%. And why is that? In large part because once we achieve 10%, then we're in the position to be able to actually have more control or more domain or more agency over the type of development that is happening within our community. As we all know, 40B projects, when you are under the 10% threshold, are basically state dictated. We have at times raised legitimate concerns on behalf of residents that have been met with nothing but thank you, but we're moving forward as planned. And so we have, as a town, so passionately worked to get us to that 10% mark so that we feel like we have more autonomy, more control, and no longer have to cede control to the state mandates in that realm. Yet in the same chapter, 40A, we would be, under the proposal by the working group, voluntarily ceding control in a way that's not required by law, and in a way that would profoundly impact the way that development can and likely would occur within our community. And this is not an anti-development article. This is an article that says, let's do what the law requires, but let's not go far beyond it, because there's no reason to. Now, I next show the comparison between the citizens petition article and the working group's proposal, the maps. I will point out that on the left, and this was certainly inspired by the working group's work, because this was identified by them as a workable map. Again, our goal is 1696. That's our requirement. That's the target of what this article intends to do. This map, in speaking with Ms. Kokinda, as all, I think everyone, either on the working group or perhaps on the board knows, there's a lot of math involved here to make sure that this works, and we have to get this approved by the state. Now, this map has been submitted to the state and is going through the vetting process now to get a sign off to make sure that we achieve the 1696. By Ms. Kokinda's calculations, the map as it currently presents could be as high as 1747 in terms of capacity. So that's something that once we have a firm number from the state relative to this map, there is opportunity for a slight or gentle modification to get us closer to the 1696. Are we going to be able to achieve that sweet spot of 1696? Probably not. We probably want to err on the side of going, a few above that, just to make sure that we remain within compliance. In terms of any adjustment relative to this map, as I've spoken with the chairman previously and Ms. Kokinda, that's something that could easily be done in advance of town meeting after we get confirmation from the state. And at that point, it could be done via a friendly amendment. But we're talking, a very negligible, modification to the map on the left, the citizens petition article map. The map on the right, in comparison, reflects the working group's proposal. As you note, that they have 5 zones, I'll call them 5 zones, 3 that are to the west of Main Street, 2 that are to the east. The citizen petition article focuses on just 3 zones that would achieve our 1696 number. Notably, with the addition of the 2 zones, we create capacity of 663 more units that would be falling under this as a matter of right criteria. And from all that I've heard from residents, that is a real concern. And it's a real concern for a number of reasons, not the least of which is the loss of community control, which I think is very, very significant. In terms of looking at the citizens petition, again, this is a proposed revised article relative to Article 17, which is what has been advanced by this board. The citizens petition, Article 18, downsizes the proposed MBTA Communities Overlay District by limiting it again to the west of Main Street in those 3 quote-unquote zones that I talked about that are centered around the commuter realm. But I should be clear that the body of the article that is being proposed through the citizen petition is ostensibly identical to the article that is being proposed, advanced by the planning board, with three distinctions. In addition, obviously, to the maps being different, so that the count is at 1696 or closer to 1696 versus the number that's being proposed by the working group of 2359. It also looks to follow the current off-street parking requirements. This is done for one significant reason. I have seen time and time again various streets and neighborhoods come before the town council with concerns about on-street parking. And we have had to make accommodations for resident-only parking on certain streets and permitting and stickers and the like. And so the idea that we would be adding density to a neighborhood and not be able to accommodate the reality of what, of what vehicle usage looks like would do nothing but create more on-street parking. I am aware that the parking advisory has, or traffic advisory has come back and suggest and endorse that 1.5 spaces for parking is appropriate regardless of bedroom count. In my own experience in dealing with traffic advisory, that has not been adequate. And so what I have modified in this proposed article is simply going back to what our current requirement is: 1.5 spaces for 1 and 2 bedrooms and 2 spaces for 3 bedrooms plus. That's the distinction. And the last change that was made to the article relates to the planning board's engagement with other stakeholders. And it talks in there about the review process and involving municipal boards and officials when appropriate. And the revised article goes a step further and says not only municipal boards and officials, but also in all instances, the planning board shall seek the input of the public. That's an affirmative obligation that's established. I think this board would agree that it's good practice to have that level of public input. And I think memorializing that within this zoning bylaw would make a lot of sense. So for purposes of comparison, this is what we're looking at. Number of units. Citizens petition, the intention is to be at the state minimum of 1696, understanding that that might be adjusted by a few to make sure that we're within compliance. And that's as compared with the working groups, which is 2359 or 663 excess capacity units. The other comparison, off-street parking, again, as I mentioned, 1.5 spaces for 1 and 2 bedrooms, 2 spaces for 3+ bedrooms. Current regulations require as much. The working group has tried to contract that number and make it 1.5 units across the board. I don't think it's realistic that a 3 or 4 bedroom unit have only 1.5 parking spaces. I think that's going to ultimately mean an overflow of parking onto the streets, which would, have an impact on residential experience. The other piece, again, public input to the planning board, required always as a matter of obligation, not mentioned within the working group's article. Maybe an oversight. I don't expect there would be issue with it, but that's just the distinction between the two. And then finally, a nuanced wording: municipal boards or officials input to planning board wherever appropriate as compared with when appropriate. Certainly open to interpretation whenever, just meant to be a bit more inclusive in terms of when those boards and officials would be engaged. I know that a lot of focus has been placed on this particular building, and I don't mean to call it out again, but I know it's been used in other slides and other presentations, so I thought I would stick with the continuity of it. So this is a property in Chestnut Street, which has been used as the model or an example of what could be relative to this MBTA's community, the enactment of the new law. I should point out that some of the advantages of Article 18, which is before you tonight, deal with, again, meeting minimum compliance of the law, but which preserves our state funding and avoids litigation. That's an important piece. I think it's a very practical aspect, and I think most reasonably minded folks share that objective. It also respects the public concerns over state overreach and too much neighborhood density. And I'll say that of anything that I've heard through this process, the feeling that the community believes that the state is forcing its will onto what should be localized decision-making is a real concern. And I think that there is valid reason to feel that way. This, as I had earlier mentioned, is a one-size-fits-all approach to an issue that is not a one-size-fits-all solution. And we have different communities that have different infrastructure and different abilities to comply in different ways. But we know how to best zone and regulate development within our own communities. And there are legitimate concerns about neighborhood density. I respect those concerns that our neighbors have raised. Relative to that, we all have neighbors that have raised that, right? I mean, we're all in this together as a community. And I think that being able to recognize and respect the fact that the vast majority of people that I've heard from on this issue, and I would argue to say the large majority consensus on this issue is, yeah, we have to comply with this law, but why are we doing more than we need to? And I know that this board has heard a very similar sentiment. And so I think that that's really what became the motivation behind this. I listened to the constituents, I heard their concerns, I shared their concerns, and I wanted to approach this in a way that addressed threading a needle that nobody candidly, I think if given the choice, would feel compelled to thread in this way, but we're left with what we are, so we have to deal with it. Another advantage to this Article 18 is that it protects our independence. And again, being able to have agency over our own local zoning decisions is important because we make the best decisions because we know our community better than anyone at Beacon Hill or anyone else in another community. We know, and so by being able to have this zone, district comport with the law but not exceed it, it means that we have more real estate and more acreage that we have control over going forward. So that means that we can, to the greatest extent possible, make sure that the limited acreage that we do ultimately have as a community is best utilized for the purposes that best benefit our community and the residents that live within it. It also gives Wakefield, this article, as Article 18 gives Wakefield the opportunity to explore more ways to address affordability in senior housing. As I mentioned from the outset, neither of these is addressed through 48 Section 3A. We know that. Affordability, in fact, it in no way factors into this. And senior housing is prohibited because that would be based upon age. I think we have a tremendous need within our community for affordable housing, and how that gets established and worked out so that we can have generational residents and families stay within our communities. That's important. I recognize that, and I understand the need is significant. I had the opportunity to speak with the chairman on this specifically, and I think we're on the same page there that we need to figure out ways to make it more affordable in our community for people to live. And that's just not, that's not only in how we address issues of tax, which is what I try to do in my capacity as a town councilor, but it's also thinking about how we impact our housing to do that. We have an affordable housing trust that has been in place but dormant for some time. We've recently seeded that further with money, ARPA funds, that puts us at about $1 million, I think, or thereabouts. And I'm looking forward to what that affordable housing trust will mean, both in terms of helping first-time home buyers, but also seniors. And the other piece to this is we also have a real issue in town with senior housing. So I think we need to think about how we can create market rate or affordable senior housing for those that are maybe looking to downsize, those that are maybe empty nesters, or for whatever reason feel that they need to find different accommodations than where they're currently residing. And I understand and respect that. I think to the extent we can check the box of meeting this state mandate, but not exceeding it, and then have a robust discussion about ways in which, because let's face it, the working group has a lot of momentum based upon the evaluation that they've done as a part of their work. That's meaningful data, that's meaningful information. That work has begun. So let's keep moving with it to see, okay, how can we leverage that and that work in a way that will deliver for us results as a community that we'll benefit from. And I think that there are opportunities for that going forward. I don't think stuffing all of that under the guise of this 40A, 3A is the way to do that. I think 40A, 3A is something that we have to do as a community so we don't lose the funding or face litigation. But beyond that, I think that opens up a discussion for us to look at things in different ways. I understand where the planning board has been coming from in terms of in the working group, in terms of expanding the zone or the district, and the reasons for it. I do, though, think even if those were the objectives to be achieved, this expanded district, as has been proposed by the working group, isn't the best way to do that. I think there are other ways that can be accomplished in a more meaningful way. And I give a case in point when I talk about affordability, because we keep having a focus on this particular multifamily. And I don't mean to pick on this by any means. It's I'm sure lovely inside. But when we look at the recent sales in that building, $750,000. And the year before, $725,000. I think we could all stipulate that's not affordable housing. That's not affordable. Now, that's within close proximity. I think about a block to the commuter rail, which is convenient. It's great real estate if you can afford it. Most people can't. $750,000 is what we're looking at, for at least 2 of those units. That's not affordable. And that's exactly what we'd be looking at, multiplied by many times over. I don't believe that offering as a matter of right to developers who are driven by profit, as understandably they will be. Developers are in it to make money and maximize their profit potential. That's what we're talking about here. So we're not talking about making it more affordable for people to live. We're talking about making it more profitable for developers to come in as a matter of right without any meaningful oversight in the way, for example, that the ZBA would provide, or any other local zoning that we may be able to come up with independently and specific to our community. So I'll end by this image, because I think it's an important imagery. This is where I see us at right now. As I indicate, unfortunately, given the state mandate, our choices are limited. But if we think about Goldilocks and the Three Bears, we had choices in that fairy tale, right? I think to the far left, to just violate the law and do nothing doesn't make a lot of practical sense. I can understand why people are opposed to this law with good reason, but the law exists, and while it exists, we need to be within compliance of it, period. To the far right, when we're talking about the working group's proposal of exceeding the law by 663 units, again, that is ceding control. That is ceding decision-making to the state level when it should be handled at the local level, when I am confident we can do a better job. And I think historically we always have done a better job. And finally, the just right, if you will, is where I see the citizen petition Article 18. It meets in the middle. It is compliant with the law, but it doesn't exceed the law. And I can say that from my perspective and from my listening to residents over the last many months, that's where people want to be. They understand that we need to follow the law. They don't want to exceed what we're required to do, because every step that we take that allows for the state to take control is authority and control that we lose as a community. And I don't think that's the outcome we're looking for. So with that, Mr. Chairman, I've concluded this. I'm happy to answer questions. And I know that the planning board is very familiar with this law and also the other article. And as I said, this article mirrors it almost exactly, with the exceptions I've laid out.
Thank you, Councilor Dombrowski. I appreciate the opportunity to for you to walk through the citizens petition, and I think point out distinctions. Just for clarification, and I've really also enjoyed our ability to discuss the opportunities that we have within our town, within our zoning, with MBTA communities. And one of the things we did discuss really was the widespread need for housing that is able to support our downtown commercial districts, and also the importance of family housing. So, which is the central focus of MBTA 3A. And all of these things, I think, have come up in our public discussions. And they really are sort of equal weight: family housing, senior housing, and the term affordable really can and does have a pretty broad meaning here. Because a lot of homeowners, a lot of renters in town are reporting being cost burdened, spending more than 30% of their monthly income for housing expenses. And so that's why that's sort of the working definition of affordability. We're not talking about deeply subsidized or income restricted public housing. We're really talking about more housing stock that more people, more families can afford. And so I think that's important to level set and understand some of the context for our discussions and the terms being used. With that, I think we would like to open it up to the public. And again, please say your name, please turn your camera on, and we've got a lot of people on the call, so we want to make sure everyone keeps to the 5-minute mark maximum. And I think we've got one hand raised already. Where are you? Ms. Millward.
Hello, my name is Dawn Millward. I reside at 18 Emerald Street. Again, thank you for holding this forum. Mr. Dabrowski, thank you for speaking today and putting forth what you spoke about. I think you really heard the community and the voice of the community, and I appreciate you stepping up. So I've been to several of these forums. The majority of the people that I have heard speak at these forums are against the proposed MBTA zoning and going over and beyond the requirements. I think the community has spoken very loudly and clearly, and it just seems as though the planning board isn't hearing us at all. They've made little to no changes. I really do think the zone should have been looked at and been not so condensed to one area that is pretty already congested. Parking is already a huge concern. And you should have considered expanding the zone and looking at projects that were already taking place that could have been added in. If it was up to me, I think as a community we should not even go forth with this. However, I do understand that we have received millions of dollars in grants, and abiding by the law is something we need to do. And abiding by the law just means keeping it to what the requirements are. There's no need to go above and beyond. And by people saying they don't want to go above and beyond, we're not against developing and moving on. We've overdeveloped Wakefield so much in such a short time. Stick to the requirements. That's why they're there. I just think the plan that has been put forth just continues to support the overdevelopment of Wakefield. So, I'm pretty sure the majority of people that are on this have heard my stance. Like I will be voting this down no come the April meeting. So again, Mr. Dombrowski, I truly appreciate you coming forward with this plan and listening to the community's voice. Thank you.
Ms. Millward, can I ask you just one question?
Sure.
I didn't understand your comment about consider expanding the zone.
So where it is right now, just we didn't include any parts of Greenwood. You're
Okay.
just looking at one, I just think if you used more of Wakefield, it would have been better. Areas like Pearl Street, Chestnut, all that, the parking on those streets are already so congested, and those are parts of the plan. I would ask anyone to drive up Pearl Street, a one-way street that everyone already parks on the driveway. I mean, I'm sorry, on the road. So yeah, just expanding where the zone should have been.
All right, thank you.
Thank you.
Do we have anyone else? Ms. Della Volpe.
Good evening, Brahma Delavopi, 8 Cyrus Street. Councilor Dombrowski, thanks very, very much for your presentation. And for basically giving Wakefield voters a choice in how they vote. So that's very much appreciated, and all the details that you offered here tonight. I just wanted to make it clear that there is a lot of confusion about the affordability aspect of this. And I think Councilor Dombrowski did a very good job to say that this is not affordable housing. Because a lot of people are under the misconception that it includes affordable housing. I'll go so far to say is that I think particularly the working groups plan will damage our standing as far as 40B is concerned, because it just adds that many more housing units to our stock, therefore harder to reach our 10%. I would also like to mention, to remind everybody, that when these things get built, and they will get built, that the developer can still go to the ZBA, the Zoning Board of Appeals, to ask for variances. They most likely will go to the ZBA to ask for variances for things like parking, setbacks, and I'm not sure about height of building, but those are very common examples of what developers ask for zoning relief on. So I just wanted to remind everyone that the variances are very much there. The possibility of a developer asking for variances. So what you see is not necessarily what you're going to get. Parking in particular is something that's asked at, I'll say, virtually every larger development, relief of parking requirements. And I don't see why it would be any different for some of these. So I did want to make one thing clear, that Councilor Dombrowski said that, we have to comply. Well, technically, no. That is up to the voters at town meeting. As we all know, Milton and other towns are looking very much at just saying no, even to the minimum mandate. That is basically up to town meeting voters, whether they decide to vote in favor of the working groups scenario, Councilor Dombrowski's scenario, or no scenario at all. So I just wanted to throw that in. Yes, it could include litigation, but it is a definite possibility. And again, that is up to the Wakefield voters at town meeting. Thank you again for the presentation.
Thank you, Ms. Della Volpe. All right. I think we have one more. Julie.
Hello, Julie Scott, 4 Central Street, Wakefield. Just a couple comments. Watching last night's town council meeting, it was not surprising for me as a teacher to hear Superintendent Lyons talk about the upcoming school concerns that he has over the next 5 years or so. And in the discussion last night, he was asked specifically about this MBTA issue and growth and development in the town. And having lived in Wakefield for my whole life, I do know that the Woodville School has had work. I know that the Dahlberg School has had work. The Galvin, we've got a new school. The Walton School had an addition. When I think of the community schools in Wakefield that have not had work, I know it's the Greenwood School. And I would think that the next building we would work on would be the Greenwood School. Logic would say that's probably what we would be doing. I am still so concerned about putting so much density in one area of our community. It's a burden. And I've said this at a number of meetings. I am looking for the burden to be shared. And I've made this point a number of times, so I'm thinking about in the future where our money for our community schools will be going. And is that where some of the burden for this could go? Because with building, no matter what people say, comes students. And that's all. I'm looking for a plan. I so appreciate this, Ed. This is so much better. But ultimately, I'm hoping there's a way we can share some of the burden. And in the future, I think the work for the public schools will be going into Greenwood. And I keep thinking Greenwood needs to share some of this burden, even if the smallest portion possible, just something. Having grown up on the west side, we already have a lot. And that's all. Thank you. Thank you for bringing this forward, Ed. I really appreciate being listened to. Thank you.
Thank you very much, Ms. Scott. Marcy Scott, Macaulay.
Yes, Scott Macaulay, 32 Walden Road. Ed, can you go back to slide 5 for a second on your presentation? I just had a question on that. You have the current multifamily unit capacity is 1,641. If I understand that correctly, that's 1,641 somehow type of multifamily units that are currently in that zone. You muted, Ed. Sorry.
Capacity, yes.
So that's the capacity that can be zoned in that, but currently I think that's zoned for 2-family and not 3-family.
I'll defer to the chairman on that.
Yeah, Counselor Dombrowski. So to be clear, the 1,641 units that's being denoted are the houses that exist today within the map that is the basis of the working group / planning board zoning bylaw amendment.
Okay.
If
So
that
that's-
same analysis was done on the map that's being set forth by Councilor Dombrowski's citizen petition, that 1641 would go down because it doesn't include the same area.
So would you say a majority of the homes in that area are currently multifamily, or there's a 50-50? Do we have a breakdown of what that is?
I'll have to reference that to staff member Kokinda regarding that breakdown. I believe that analysis has been done.
Yes, good evening. We did do an analysis of that area. Again, the kind of 5 districts, 4, whatever you want to call it, for the planning board and working group. And it was based on different neighborhoods. There was, more single family in the west side, but with multifamily sprinkled in, everything from condos and apartments. In the kind of the interior area, I don't have the numbers right in front of me. This is just based off memory.
Which is fine, but would you say that in either plan, would the majority of that be single-family homes that are currently in those areas, or would it be a mix, maybe 50-50? Is there a rough
It would be a
percentage?
mix. I couldn't give you, I'd be afraid to speak on that publicly without having those numbers right in front of me. But I would say it would be a mix of single family and everything from 2-family up to 4 or higher.
Okay, because, and just to point out, so even if there is multifamilies in this area that are 2-family or 3-family, those units can be then converted into what would be 4 units or more, because the minimum is more than 3, the way that I'm reading this. So to be compliant with that would have to be more than 3 units. So a single-family home could be turned into a 4-unit building. A 2-family home could be turned into a 4-unit building. The other question that I had, and I'm asking for both the board and for Mr. Dombrowski, is people keep touting around on this, the buckets of money, which has been increased to 4 different buckets opposed to original 3, and even more than that, I think now. But what exactly are those funds to the town? And what exactly are those numbers over the past 10 years? Because I keep hearing 3 million, 2 million. I think it's more representative of about $300,000 a year, if I was doing my math correctly, but I'm wondering if anybody has those exact numbers, because I think there's a lot of fear in those numbers, because those are not guaranteed. Those are grants that the state decides whether they're gonna give us our own money back. And there is absolutely no guarantee that we're gonna get any of that going into the future because the state's economy is starting to go down. So I'm just wondering exactly what that number is that we get from the state.
I can give you anecdotally just a couple of recent examples. One of them is the water main project that went down North Avenue towards the head of the lake. That was approximately $2 million, I believe. The other was along Albion Street, about $900,000. And that was within, I think, the last 2 or 3 budget cycles. I was speaking with our town administrator about this to get some additional numbers that he's gathering on that, but it's significant because it includes Mass Works projects. There's a lot more opportunity through projects like Mass Works, for instance, and every indication is that as we continue to see the state shifting more towards a grant-based funding, and I'm not suggesting that's appropriate, but that's what's happening, as more towards grant-based funding, that more and more of the grant opportunities will be consumed by those that are within compliance of this law. I mean, this, again, as I mentioned earlier, if you think of it as a carrot and stick approach,
right,
it's a heavy stick, and not, and the carrot is dangling out there. But
Oh, there's no carrot. It's mainly a
yeah, right,
so
exactly.
just in those numbers alone, Ed, you're talking almost $3 million in just water main, sewer main upgrade in just 2 small areas of town. Consider
Well,
what,
Albion wasn't water main sewer main, but
it wasn't. So
yeah,
$2 million
but yes,
just for a portion of that line on North Avenue. Consider what that's going to cost the town when we need to upgrade all of the lines in these zones because we're going to be more than doubling the capacity that's already there. What that's going to cost the town in the long run. Consider that the town census has us at 2.44 people per household. I'm assuming that 0.44 is children. When you're more than doubling the capacity in that area, that's a sizable number of children that's going to add to the total deficit that we're going to be facing that goes towards the schools. If we're looking at $53 million budget, some 3,000, I don't know how many kids, I think it works out to be, if you break it down, it's about $15,000 per student. If you're adding 500 students, that's a lot of money. Where are they going? They're going to the Walton School? They're going to the Doyle School? Where are you going to fit all those kids? I'm just saying that home they keep pointing out on Chestnut Street, they did a nice job in remodeling it, but if you look at the yard, it's like 10 by 15. How is that child friendly? Where are these kids supposed to play? I'm just saying, we're a town for a reason. We're a town because we've been a town. We don't want to be a city. So I'm just saying, and Ed, I appreciate you for listening to the people who are complaining that this board has not been listening to people in Wakefield, because they haven't. They've gone above and beyond, and they're just kind of flying in the face of what the public wanted. It should have been part in Greenwood, should have been part in Wakefield, it should have been spread out, but they didn't do that because they didn't want to listen to anybody, they just did their own thing. Ed came back with his own version, but it's still, in my opinion, way too much. You need to look at all these homes. There's a moratorium on gas for multifamily homes. They're all going to need to be electric, or they're going to need to be oil. We voted on this lovely extended energy thing, which my understanding of reading this is that that's not going to have to apply to these homes. They can put oil in and they can do whatever they want. So I'm just saying, there's a lot of things to consider that's going to cost the town, the taxpayers, exponentially more money than if we got sued by the state, which I don't think they have standing. So I'm just putting all that out there.
Leo, do you mind if I just clarify something real quick that Mr. McCauley mentioned? Oh, okay. When you said that all of these lots could be up to 4 family, that is not completely accurate. I just want the public to know that, because you still need to abide by the parking regs. So what's being proposed with Mr. Dombrowski's bylaw, and then with the planning board, they still need to meet the needs of what the parking has to be. And so they need to prove that. And so some of these lots may not even allow, 4 or 3, or, be lucky, some of them might get 2. So not all of them. I just want to clarify that are going to be for. That is the max that someone could do if they could make all the dimensional regs work. So I just wanted to clarify that.
So where does it actually state that? Because that's not in the guidelines. It just says as by right.
I believe it's right at the beginning. At the bylaw, it says up to maximum of 4 dwelling units per parcel.
Yeah,
It's 190.
in the
Bear with
state,
me.
in the state's guidelines. Is that what you're talking about?
I'm talking about the local bylaw that's put into place that we would be abiding by.
But the local bylaws don't apply if it's by right. The state has control over all the zoning.
That's right.
That's not correct. We would be abiding by this local bylaw for this.
I don't think so.
I don't think that's correct.
I'd like more info on
I'm sorry, I don't know who just spoke.
I'll step in for a second, just as one of the people who's been going through this. So to be clear, by right means that someone has the right, if they can also meet all the other dimensional regulations of the local bylaw, they are entitled to have the right to build up to 4 units. However, that does not wipe away the requirements for dimensional regulations that are on the books, or as Aaron mentioned, the parking regulations. So if a developer had a parcel that for whatever reason could not meet the dimensional regulations that are on the books today and that are included as part of this bylaw, then they don't have the right to proceed with a building. With that being said, it also means that we as a town don't have the right to deny an application for a building permit solely on the basis that it's a 4-family. So that's the slight nuance. But if they can prove that their project will meet all the regulations that are on the books as part of our local bylaws, then they're entitled to get that building permit. But if they can't, that means that we still have the right to reject that building permit.
One thing just to add to that, going off of what Jim and Aaron have talked about, anytime somebody has a lot, there are uses that are listed in the code, local code, as a by right or special permit or prohibited. And so if you're trying to build a single family home on a lot, let's say it doesn't meet the dimensional requirements of even a single family lot, you would not be able to do that. And that's similar. So dimensional requirements are your setbacks, your minimum lot size. You would also have parking requirements. So all of those things are going to come into play. By right just means that you don't have to go through a review process for that particular use. You would still have to meet all of the other criteria.
I understand what you're saying, but it takes a few smart attorneys like we have in town to then roll over the board and roll over the town and go to the state and get that overturned. So when you say that they have to abide and they can't, there's been many instances where they do, and the state comes back and says, no, sorry, you got to allow them to do that. The state's going to have full control over this whole area because we've given that away. By right, Wakefield has the authority to make its own zoning laws. The state can't make those for us. By right, by law, they can't make those for us. That's why they're having us vote on this zone, and they didn't say, this is where it's going, Wakefield. They can't do that by law. Do you know why they can't do that? You as the board should. Can you please explain to everybody listening on here? Ed, do you know that answer?
So I'm not understanding what your question is. If you're talking about an applicant does not, unless they're going for very specific variances, you don't have a right to appeal to the state for a waiver for the local bylaws. All of those bylaw applications for special permits or variances are controlled at the local level and are in Wakefield routed to the Zoning Board of Appeals.
Right.
So there isn't like this higher state level authority that you can appeal to. If you're talking about why the state hasn't gone and done a localized zoning effort for each individual community, it's because the law was crafted such that the state wanted to have the general parameters of these multifamily districts by, as of right. But give the local communities some level of control. But and respectfully, Mr. Chairman, I think we're kind of we're getting into some rather side conversations, and I think we should be focusing the conversation to the citizen petition that is set forth right now. Mr. Chairman, you're still muted.
You're muted, Theo.
No, I appreciate the opportunity to engage the question of what by right means, but I do agree, Scott. I think you've taken us. I think there's a significant misunderstanding of what by right means, and yeah, what we've done in the bylaw and what is in the citizens petition is 4 units at most on any given lot. So, I think there's a limit. I would like to Jim's point, I would like to invite other members of the public to ask questions about the citizens petition as has been presented here tonight. Rosemary. All right, Rosemary, you are muted. Where are you? All right. So I think we're having a problem with Rosemary's mic. Anyone else? All right, Rosemary, you've been able to unmute. Okay. Anyone else? On the, all right. Not seeing any other hands raised. I'd like to invite Eleanor Axelrod. Thank you. All right, you've got your hand raised.
Hi, Eleanor Axelrod, 19 Sheffield Road. Hope you can hear me okay.
Yep.
And I apologize, I signed on late, so missed the beginning. I guess the pressing question I had was how many new units this plan would create. And then in looking at the FAQs from the state, it mentioned that in building a MBTA community zone, it shouldn't exceed 25% of the town capacity. So I just wanted to see if you had looked at that, because currently the number of units that meet the 3A and above criteria are 23%, according to the 2020 census. And I think our numbers might be actually higher, but 23% equates to about, I think it was 2,600 units or 2,300 units. I had emailed you guys about it, but I just wanted to to see what happens, you know, if we can be capped at that 25%. Does that question make sense?
It does. I'll invite Jim and Aaron and Samantha perhaps to speak to that.
If the question is related to the 25%, so Wakefield has, I think the number off the top of my head is roughly 11,500 units, give or take, as the existing housing stock. So 25% of that is roughly 2,875, which none of the petitions, including the one that we're here to talk about tonight, are approaching. And as it relates to the question about how many housing units would be developed, to be clear, this is a citizens petition, and the working group and the planning board have not done any analysis of this. But in order to do so, that someone would have to go through and verify the number of existing units within the district, and then do a comparative analysis of what the capacity is. Councilor Dombrowski, you can speak to this more, but I know that you've been going back and forth with Ms. Kokinda regarding, I don't think that you have a final number in terms of the anticipated capacity for this district.
Correct. So this is 1696 being the requirement that's been the mandate that's been forced onto Wakefield. The map as identified now is subject to the state's further sign off, and that's why I would say it's, you know, as with the map that was presented by the working group, was also reviewed by the state for sign off. We're at about 1747 if we were to keep the map exactly as it is by our town calculations, although they've not been verified by the state. So the objective of this article is to get as close to the bare minimum as possible. As I had mentioned earlier in my remarks, 1696 may not be feasible. Could it be 1700 or could it be 1710? Potentially, yes. But as close to 1696 as we can get is what the objective of this warrant article is. And to the earlier comments too, to be clear, I understand what people's perspectives relative to this. I understand that a lot of the community is not in favor of this 40A. I am not advocating for this 40A. I do not believe the 40A section 3A is the right law here. It's one size fits all, as I mentioned in my presentation. And I don't think that that's the best approach to zoning. I think zoning should be maintained at the local level. But I'm also being realistic about what we're presented with here as a community. And when we're faced with the state mandating that we create something, and bear in mind, as some have pointed out, we technically don't have to do anything. And I think that's the state's workaround, because they say, well, you don't technically have to comply, but if you don't comply, then you're not going to get the funding. And there's all these issues, and obviously there's threatened litigation too, as you're well aware. I am not promoting this section 3A. I don't think it's good law, but it's the law that we have, and I think we have to be mindful of that in our decision making. We're all ultimately on the same team here. We're all residents of Wakefield. We're all going to be impacted by any of these changes. And I recognize that, and I'm very sensitive to the fact that people on the west side are going to be more impacted by these changes than perhaps someone in Greenwood or you know, other parts of town. But I come before this body not as a planning board expert. Don't pretend to be. I've relied significantly on the good work that I think has been done by the planning board in crunching numbers and things of that nature. I have heard the concerns that residents have raised about not feeling as if they are heard during this process. I understand and appreciate and share many of those concerns. And that's what brought me to present this, again, to try to maintain as much autonomy. I'm trying to fight for as much local autonomy as I can while being in compliance with the law so that we don't lose significant funding sources. So I think that it's an important distinction I want to make here. I'm not trying to sell 40A, section 3A on anyone, but it's the law as it stands now. And this is the least impactful means of being compliant, you know, and that's what's being advanced here through this article.
May I add one more comment? Is that okay through the chairman?
Of course.
I'm just going to go ahead. Ed, I agree with everything you've said. I'm not.
We lost Jelena.
Sorry. I agree with everything you've said. Ed, I'm not in favor of doing nothing. So I appreciate that you're working towards the minimum. One concern I have is this is so focused on the west side, and it risks losing single family homes, which are, you know, pretty valuable, and how you can house multi-generation families, which is how we are moving. towards, and converting them to rentals. I think there are other approaches that towns have taken, like putting the district around high-rise and more developed areas, doing mixed-use areas like on North Ave, Main Street, Foundry. I really wish as a community we could take a look at that and not just put this all on one neighborhood and impact one neighborhood. So that's all. But I appreciate your efforts to work towards a minimum and to work towards a solution.
Thank you. Who we got? Jane?
Hi, I'm Jane McClellan and I live at 59 Cedar Street. And I just have a clarification question on the chart that Mr. Dombrowski has up right now. So it says current multifamily unit capacity in the overlay area is 1,641 right now. And then there's a deficit of 55 that we would need to meet the 1696 number. But that 1641 number, I didn't think we could use what we already had existing. I thought we had to add to that. Am I not understanding correctly?
The question is first directed to the citizens petitioner, and then we can add some context too.
Sure. So there are a number of projects that don't qualify under the way that 3A is established. So a lot of projects that have been in process, and I point specifically to Foundry Street as being one such example. We've obviously had significant development along that corridor in recent years. And that's been like one of the challenges that we've run into relative to 40A. And when 40A first came out, before the working group even began their work, that was one of the frustrations that Wakefield had, because Wakefield as a community felt as if we had really done our fair share in terms of creating new housing opportunities in recent years, a lot of which was not being counted. But in terms of the specifics, I would really defer to Mr. Hogan and the working group, because they have crunched the numbers. And again, I've been, as I mentioned from the outset, I've been dependent upon the work that they have done. So I would defer to him to further expound upon that answer.
Yeah, so Jane, just in terms of the way that this chart is working, there's a couple things that are slightly not 100% right. So there is no current multifamily unit capacity in terms of a district that exists today. What that number represents is if you take the district that the working group proposed that has the capacity of the 2,359, and you just look at the housing units that exist in that district today, there's 1,641. So if you draw a smaller district, then that number would obviously go down because it'd be less, less area of houses that exist today. So that's kind of the first thing. I think your question in terms of what we need to do in order to meet the law is we need to draw a district that, based on the regulations that we pass as a community, could allow for a theoretical 1,696. So if, for example, Foundry Street is a classic question that a lot of people have brought up, there are a number of reasons why the working group did not include Foundry Street when we did this analysis. One of them is that, for example, the large Grayson Loss project, you can only get credit for 4 units of housing on that lot by including that lot, because you have to take the lots as exist today, and you can only, basically, if you say 4 units as of right, you can only get credit for 4 units for that whole giant lot. And what it did is it really dramatically decreased the average density of our district, such that we were not in compliance with that 15 units per acre. One of the other things we did look at is we looked at, what if you took a smaller district and you made it so you could have a lot more units that were allowed as of right? And what that analysis yielded is that you'd have to have significantly higher buildings that would be allowed as of right, which did not feel appropriate based on the community character that the working group was trying to respect. So the working group tried to keep a district that was as close to that minimum density requirement as possible, while making it so that covered, the existing height and those other criterion. But those are kind of the basics of what the district and how it came to be, and why some of the laws elements impacted it. Did that answer your question?
Yes. When you talked about, when on this chart, it says deficit to meet the mandate. I looked at it and thought that meant that we only needed to have 55 more units in the overlay area to meet the mandate, but I might be looking at that incorrectly.
We need to get to 1696 to meet the mandate total. Yes.
Right.
So this is representative of the number the working group had devised as 1641 in the context of the 1696.
Just to clarify.
Thank you, Aaron.
Sorry. Theo, do you want to, or?
No, you can go ahead.
So I guess basically what that 1641 number is, if you took that, I think Jim was just, saying this, all those 5 districts in the proposed, and I hate going back to the other proposal, those 5 districts basically started from 0, redeveloped all those properties. That would give you the 1696 if you put in all the dimensions, the number of units that's being proposed through the bylaw. Currently at this time, the 1641 is what you are, what is currently the number of housing units that you find within that district. So it just was giving people an idea of how many housing units are already within those districts and what the state is looking for that area. Does that clarify?
Yeah, and let me jump in there too, Jane. The 1641 maps to the working group recommendation. We do not have a data point for the current multifamily unit capacity of the smaller map suggested by the citizens petition. The citizens petition doesn't have the 1641 because it's a smaller map. So I think there's yeah, that's what I'm trying to say. Does that make sense? All right, thank you. Okay.
Thank you.
All right. I know Julie and Eleanor have raised their hands. Before we go back to others who have spoken, is there anyone else on the call who has questions regarding the citizens petition? All right. Julie Scott.
Hi again, Julie Scott, 4 Central Street. I was going to wait until town meeting to bring this up, but since we have a new proposal.
Julie, can you turn your camera on?
Yeah, 1 second. Can you see me?
Yeah.
Okay, I was going to wait until town meeting to bring this up, but I'm going to bring it up tonight because I want everybody on the call to be thinking about this and maybe even reaching out to the fire department as well. I have grew up in a family of police and firefighter, military family. And over the years, since I was a child, my grandfather was on the police department. I knew a lot of firemen, and the job is so different now, and water pressure is very different in Wakefield now. I live on Central Street, and a year and a half ago, there was a house fire just off between Central Street and Vernon Street, and the whole house was lost. And I walked from my house, I wanted to see the fire, and there were a number of fire trucks from neighboring communities, mutual aid trucks, parked at the Herd School, pumping water with their hoses. They weren't attending to the fire, but they were giving our fire department needed water because of low water pressure. I know for a fact that there were 2 water accesses on the street that had the house fire. There was not enough water pressure to A, fight the fire using the 2 fire hydrants, and B, also to have the houses on the streets and in the neighborhood, the neighboring neighborhoods, have enough water pressure. So And the reasoning is we are overbuilding throughout the community. This particular neighborhood is not the only neighborhood who has water pressure issues when fighting a fire. I know we've run this process, part of it anyway, in front of the police department, but we haven't talked to the fire department about this. And my point is putting this stress in just one section of town. Infrastructure, infrastructure, infrastructure. I'm looking at the website, mapc.org. I can share this with people later, maybe on Facebook, or if you'd like it emailed to you, I can get that to you. These are their talking points, and here's
I'm sorry. So the point is well taken that you're making, is that you're concerned that
well, let me read you what
either petition doesn't well, I guess I'm not sure. Can you just state it plainly?
So I'm reading from MAPC's talking points. If people are concerned that we don't have the water and sewer infrastructure for all this new development, this is the MAPC website. They say municipalities don't need to spend money upgrading their water and sewer infrastructure in anticipation of new development associated with the MBTA communities law. When multifamily housing is proposed, the developer will need to make the case that there is adequate infrastructure to support their project. For example, they may choose to construct on an on-site sewer treatment facility if there is an existing municipal capacity. Further, compliance with Section 3A allows municipalities to access MassWorks and Housing Works, two state programs that provide substantial capital grants to help cities and towns fund public infrastructure projects that support and accelerate housing production.
Okay.
My concern is we need to, at town meeting, specifically, whether for both plans that have been presented, how will this impact the capability to fight a fire and water pressure? Because I want the burden shared, not just one section of town. Thank you.
All right. Thank you. All right. I would like to hear from other members of the public before and anyone else has spoken, or before others who have spoken. And we are at the 8:30 mark. Rosemarie, do you have a new comment to make? And can you turn your camera on and unmute yourself? All right. We've lost you. Okay. I would like to invite the members of the planning board. Do you have questions for Councilor Dombrowski about the citizens petition? And
Yeah, Theo, I have a couple
Yeah,
questions to
thanks.
start.
Yeah.
Ed, thank you for presenting this. I appreciate it. The work you put into it. Now, you had said you believe that your district will comply, but until the state looks at it, you're not sure. If this needs to be expanded, that can't be done at town meeting, can it?
Well, what I said is that the state needs to sign off on it, just like the state had signed. It's the same exact process, Mr. Lowry, as you're probably aware of, that the working group's submission had gone through with the state. GIS is involved. Ms. Kokinda is working through on that, and she just hasn't gotten back the confirmation. But by all indications, she believes that this district has created a 1747. And no, certainly no one's going to be looking to chart out maps at town meeting. And I'm glad you raised the point, because I actually raised it with the chairman. The chairman and I spoke about that. And we talked about the idea that if, be it any iteration of a map that departs from what has been currently submitted and on record with the town, then certainly there would need to be thought put into making adjustments prior to town meeting to then allow for a friendly amendment for any necessary changes. So that certainly has been anticipated, but this is no different than the process that had been followed with the working group's submission.
Okay, but just to be clear, this hasn't been vetted yet, so potentially this could be voted on and then deemed not compliant from the state, correct?
Well, no, it has been vetted, and we'll have the response from the state certainly well before town meeting, just like the working group's map that was submitted prior to this map was vetted and signed off on by the state beforehand. But we're not on the edge here with this. Again, the 1747 puts us at a comfortable buffer or cushion. Ms. Cookinda can speak to the math that she's done on this, but she's confident that where we're at already, we should bring us into compliance without issue. But if were there to be any issues in that unlikely event, just like if there were to be any issues with what had just recently been submitted on behalf of the working group, then there is the opportunity to make that adjustment via a friendly amendment at town meeting.
Okay, but so again, you would be potentially have to expand the map, correct? Because if something needed to be changed, you could, from already submitted, could be smaller, but making it larger really is outside the bounds of what's been presented. I just wanted to clear that up because yes, the working group did have their plan vetted prior to submitting it as an article. So I just wanted to clear that up. So, all right, thank you. The other question I had, so you've got 2+ parking spaces for any units that have 3 or more bedrooms, or just more than 3 bedrooms? Because the 3+ would mean anything above 3. Is that correct?
It's not more than 2 spaces. It's a 2-space requirement, and it's 3 bedrooms plus. Yes. So specifically 1 and 2 bed. It's consistent with what the current parking regulations are relative to this. 1.5, which I'm sure you're familiar with. 1.5 spaces for 1 and 2 bedrooms, and 2 spaces for anything above.
Okay, so if you had a 3-bedroom, that would not be 3+, that would just be 3, correct? I just wanted to clear that up. So it
Well,
seems like it should be,
yeah, but if you're actually writing it in a legal way, you're saying 3+, because otherwise, if you're just saying 3, then what if it was a 4-bedroom, right? So you'd have to accommodate for 3 and above. So that's what that provides for.
so you would say 3 or more, correct? It just seems like this is something that could be an issue.
Well, I think I'd have to go back to the specific language that's in there.
Okay,
If you want to focus on 3 or more, sure. I think 3+ covers it, but if there's any doubt, we could certainly make that adjustment.
Yeah, you may want to just make an amendment on that. That's all. So, and then your requirement for public input. How would that happen, and how would that public input need to be taken?
Well, I think, when we're talking about zoning bylaws, or really any regulations for that matter, the intention is to state what the desired purpose is, not to be overly prescriptive. And so I wouldn't suggest that this sort of a zoning bylaw, or any sort of a zoning bylaw, should go into that level of detail, in the same way that when we look at Article 17 that was advanced through the planning board, it talks about when appropriate, seeking input of municipal boards or officials. It doesn't lay out a process by which that is achieved, but it's clear that when appropriate, that is the process that should be followed. And so the way that this is written is designed to have a built-in assurance to the public that there will be public input relative to any of these projects. And that can take on any number of forms. And I wouldn't want to tell the planning board how to go about doing that, but instead, I think that this, the inclusion of that reference is to be instructive that it needs to be a part of the process in a way that the planning board deems it appropriate, much like the planning board would integrate the input from municipal boards or other public officials as warranted.
So we would need to get public input on any project, any multifamily project. And then we would need to determine how that is utilized. If it's a by right project, having people comment on it kind of takes away the by right nature, doesn't it? And in forcing the planning board to basically listen to, or, you know, have all the public come and comment on every project is kind of onerous, wouldn't you say?
I don't think getting public input is ever onerous. No, I just fundamentally disagree with that. And I think that's perhaps part of the problem that has been created through this process. The public feels like they've not been listened to sufficiently. So no, I disagree. There are plenty of opportunities, I think, that I think about where in the town council capacity, we've certainly sought public input. In fact, some of our policies require a 30-day public input period before we make a determination. Now, I understand what you're saying as a matter of right, but we also know what as a matter of right means, right? It's been talked about here this evening. So I think that the opportunity for the public to weigh in, there's intrinsic value in that. One, because the public should be heard, but two, because if someone is coming before the planning board with a project, even if it's as a matter of right, the public input may, in fact, it might be, maybe it's an abutter, maybe it's a neighbor, maybe it's someone that's had a similar experience with a similar type of development that's being pursued. There's insight and guidance and just kind of know-how that residents, I think, have that could be offered to improve the project. So I think it could actually be a win-win, both for the developer and for the community to have that kind of engagement. It might be, hey, by the way, you know, if this tree casts this shadow, or hey, lighting in this has not been successful for this reason. You know, I'm not going to try to, you know, predict all the ways in which public input could be beneficial, but I'll say, you know, unabashedly that any projects, regardless of matter of right or before special zoning requests, receiving public input, it matters. I gained from what I heard this evening from this public hearing, you know, and I think anyone who is participating in this is probably feeling similarly. But more importantly, I'm really proud of the fact that so many residents have spoken out this evening and expressed their opinion, and I think it's been a good dialogue. And I think that we should never say that dialogue in a public forum is onerous. I just fundamentally disagree with that.
And I don't think anyone here has said that. So,
well, you specifically use the word onerous.
Well, what I said in onerous is, if we need to have public input on, if we need to hear public input on every project, does that mean every single person that comes before the board on that needs to be heard?
I think that every person that seeks to be heard on a particular issue, that's a member of the public, that is a taxpayer within our community, has a right to be heard. And if that means that there are some projects that require 15 people to be heard, then that's appropriate, because that probably indicates to me that there's an issue. I suspect that by and large, most of these projects may not require or may not generate as much public interest. But for those that do, I'll be damned if I'm going to have anyone in the public not feel as if they're being heard on a project. I mean, we're looking at, this is a pretty significant hearing tonight, I would argue. We're talking about a pretty weighty issue. I think the public discourse has been appropriate. I think the number of people participating is what's anticipated, and I don't in any way find this onerous. So if something of this magnitude is able to be managed by the planning board, I'm absolutely confident that any projects that come before the planning board where public wants to be engaged and be able to have input should be welcomed.
Okay, so
wait.
I guess I think just this needs a little bit clarification, and it needs to be maybe I don't know, just defined a little bit better, because if 1,000 people came out and said they don't like a project, but it's a by right project, the planning board or whoever's seeing this would not be able to deny it. So, you know, I understand what you're trying to get at, but the logistics of it seem, just like I said, a little onerous, and I think it needs to be thought out a little bit more. That's all.
I appreciate your input on that. Thank you.
Okay.
And Aaron, you've got your hand raised to respond. And you're muted. Sorry.
I just want to clarify something too that Ed spoke on, and then just so this public knows, there was a pre-adoption application period once the planning board finalized their I'm going back to the planning board just so people can get an idea on timeline for this. Back at the beginning of January, and as the internal department staff, I submitted that. In the website, it does say to give up to 90 days for the approval process. So Mr. Dombrowski's what he's put in front of us today was not put in forward until about a month or so ago. So, you know, that doesn't give us a 90-day window. So I just don't want people to be guaranteed that I'm going to get this pre-approval from the state with, you know, requirements or changes that they would like to see if the parking works and things like that. I just want to be very clear with that as well. They did acknowledge that they have it and they're looking at it, but there was that 90-day window that is stated on their website. So I just wanted everyone to be aware of that.
Yeah.
And one more thing. So Aaron, and there is a possibility that the text from the planning board's proposal could get approved and the planning board's map not approved, and Mr. Dombrowski's text obviously not get approved, but his map be approved. So there are I believe, you know, and I'm pretty sure we're doing a map change and a zoning text. So either one of the parts on both of these, one could fail and one could pass. I just wanted to point that out.
Yeah, if I could just clarify, I
Wait.
realize that this is being called, you know, my proposal, and obviously I'm the one that's advancing it. But as a town councilor, I have the ability to submit of a warrant article. I chose not to do that, so this is a citizen's petition. So this required a number of citizens to sign off on before it was submitted, and I did that deliberately because this is not my amendment, but it's representative of the community. And so I that's why I'm referring to it as I am as a citizen's petition. Although again, I fully acknowledge that it was at my initiation and I've been seeing this through, but I think it's important to make that distinction.
I apologize, I misspoke.
No,
yeah.
of course not. But you know, but I just want the public to understand that this represents the public. This is not, it's not about me, it's about what the public, you know, outreach has been.
Yeah. And I also want to make clear that we are following and continue to follow and really strive to be transparent and to receive as much public input and engagement as possible. And that's why the working group process, why all of this has been extensive and involved and very, very deliberate. So all of which has led to a lot of strong engagement and I think significant, appropriate, and very helpful research to get us to fully understand the opportunities and the constraints that the law provides, how it's being complied, or the compliance regulations sort of regarding it, and how we can respond to it. So, and that's why the drawing the map is so complicated, as we've gone into detail and as you've mentioned. And also, just to be clear, it's specifically to Matt's point too about bringing maps to town meeting. there are a lot of variables, and should there be amendments to each map, that does, potentially become problematic, or just for the same reason that we could get a map that doesn't work. So it's just again, trying to be as informed as possible and follow a really effective process with everyone's engagement, so that and through town meeting, so that we can be as successful through this process as possible for the town.
And to be clear, I've had a number of conversations on my maps with Ms. Kokinda, and she has a high degree of confidence that the numbers as they present will pass state muster without issue. But again, it's still a technical sign off, fully acknowledged as such. And if we were anywhere close to the 1696, within a few, like give or take, yeah, that would be give pause. But Ms. Kokinda, I spoke with her recently as late this afternoon, and she has a high degree of confidence that the math as presented and the map as presented should work just fine.
Hello.
Kevin, you've got your hand raised.
Yeah, thanks for this presentation. I appreciate you taking the time that went into this and to appear here tonight. One question on the 1696. So you said that number could be closer to 1747. Now, my understanding is that a friendly amendment or a floor motion at town meeting can't enlarge a map. It can only condense a map. And I don't recall if I heard that from Town Attorney Mullen or Attorney Bobrowski, who's been consulting with the Bylaw Review Committee. He's a zoning specific attorney. Is that correct? And Aaron or Jim, you might know the answer to this as well. Or did I mishear that? To Theo's point, I would just want to make sure whatever we take before town meeting, if we pass it, then it's passed and compliant and we don't have to come back in November and redo anything.
So I can speak to that. So Kevin, you are correct. Under the guidance of Town Council Mullen, and when we discussed, when you have to make a floor amendment when it comes to the planning board's proposal or the citizens petition that's in front of us tonight, you could only shrink it. It couldn't go larger. So you'd have to stay within the four corners of what's being proposed. And so just to clarify, though, I think his 1747, he would be shrinking down. And Ed, I don't know if you want to talk a little bit more about that to get closer to the 1696. So that would be shrunk on the floor with the map. But you could not go any larger from my understanding of talking to Tom Mullen. Does that answer your question?
And were the map deemed to be after compliance review, the map may actually have a smaller number and therefore fall out, and then would be invalid. And there would be no way but for coming back to town meeting to revisit the map.
So that's why the buffer is put in as it is. I spoke with Ms. Kokinda about that. Again, because when she had done the calculation, that's what she arrived at, specifically at 1747 for the exact purpose, Mr. York, that you're raising, that you can contract and come down for that number. So the 747 was a bit of an overreach in the spirit of maintaining around the 1696, but as I had earlier mentioned, not being so close that you're like right on the edge, with that. So to give a little bit of buffer there, I know for, Moulton, the parklands there, they were considerations, if they're not includable in acreage. So as all of you know far better than I, it's very complex, calculations that are made. So the 1747 was with the intention of being able to come down potentially, but otherwise be at a number that's as close to 1696 as one could comfortably be, without splitting hairs. And so I don't think the 1696 would ever exactly be achieved, I guess, depending on how someone does the math. But the spirit of the bare minimum that's just above the law is where we're at. Yeah.
And I,
The map attached to the citizens petition is 1747.
1747, correct.
and I would just like to clarify with this group too, is these numbers that Ed's saying with high confidence that has been proposed, you know, this is through the compliance model, which is the same model that has been used through the planning board as well. And, you know, the bylaw is a separate thing. And so when it is sent for that pre-adoption to the state, they look at all the bylaw and, you know, I plug in the parking and all that. The concern that may be that rise up that's different than the planning board is the added parking, which doesn't take really into account when you do the compliance model. But when you plug in all the numbers, those are the numbers that come back and do meet the numbers that the state is looking for. So I just wanted to add that for reference.
The point being that the additional parking takes up square footage and therefore reduces the amount of potential units on a particular lot. Right.
That's where I'm getting with
Yeah.
that, but with the compliance model, they haven't gotten back to me that that's an issue yet, but something that that's very different than the model that was already put forward and we heard back from the state on. So I just wanted to make everyone aware of that.
And also Article 8A specifically addresses that by talking about the parking, saying that 1.5 spaces or 2 spaces, it says unless the number would fail to comply with the minimum requirements for the overlay district per MGL 40A section 3A, in which case 1.5 spaces shall be the minimum number required for all dwelling units, regardless of number of bedrooms. So that creates the fallback there.
Okay. Other questions, comments from board members? We do have Scott McCauley and Don Millward have raised their hands. All right. And for clarification purposes, Matt's asking questions about how public input is to be received because there's lots of very important rules and regulations regarding how public input is received, so that it is fair and transparent. One being in formal public hearings, it's asking people to speak up to 5 minutes on particular points. So Scott, I will turn to you. If you've got a comment that you have not discussed, if you've got a question that doesn't involve prior questions or comments that you've made tonight.
Certainly, Mr. Chairman, thank you for the opportunity to speak again. I just had a quick question, actually two. So because this involves zoning, I know, for instance, my neighbor wanted to have their curb cut moved over by 5 feet to accommodate parking in the driveway. But postcards needed to be sent out to all the butters and everybody within a certain radius of their home for that. Is there any type of thing that needs to be required from either of these because it involves zoning to have postcards sent out to everybody that's affected in this area? Because I don't believe that, we're all aware of this and some of us are coming into this at the last minute, as are a lot of people in the state as all this stuff comes to fruition. But I still think there's a lot of people that are just totally unaware that this is going on. And I just want to know if that's a requirement, other than putting the article in the paper and people reading about it at the last minute is the only opportunity to get to figure this out. I'm just wondering if postcards are sent out. And the second quick question I had is there anything that keeps developers from building these houses on stilts and have complete parking underneath that's totally open and exposed?
To the first point, there's a lot of requirements in terms of public notice and how how the community is informed, not only of this public hearing, but of our prior public hearings, and all of that has been met. Sending individual postcards to all residents is not part of the notice requirements.
But I believe
So
this is the first map that we're seeing of Mr. Dombrowski's overlay, which is different than what you proposed. So people aren't aware of the streets that are involved in this. So I'm just wondering how the public is notified the actual streets and house numbers that's involved in this overlay.
Yeah. So to that point, when the public hearing was, so the citizens petition was filed, and so it's available through town hall. B, we followed all the public requirements, which include multiple notices 2 weeks prior to tonight's hearing, by filing it at town hall and in the paper a couple times, and the information's on our website. So, but your point is also well taken. Is that yeah, this is coming. This is just from a timing perspective, coming close to town meeting.
The map that you have on the website doesn't list all the streets. It lists like every other street. So it lists the areas and drawn. So unless you go specifically looking on another map to see what streets are on there, the streets themselves aren't listed. And I don't believe that they're listed in the warrant.
Yeah.
Yes, they are. Yeah,
I'm sorry.
they aren't listed, and I appreciate your comment. Maybe something we could add on our website prior to town meeting.
Maybe it's something that should have been added to the warrant because the actual streets are not listed and the street numbers of the houses that are affected are not listed in either of these warrants.
Yeah, to that point, I think that's actually a criticism of public hearing laws and notifications, and somewhat certainly outside the scope of MBTA 3A and the petitions. So, but again, it is a point well taken, and it's a point gladly received. Don Millward, do you have another question regarding?
Not so much a question. I was
and different, separate from your prior comments.
It was, I just wanted to reiterate something that you had stated while I was listening. You had made a comment just after Ed was talking about how important it is to have public forums, engage the public, and how important it is. That's why you're having all of these. But I think the big contention for a lot of the Wakefield citizens is, even though you've had all these public forums and we're talking, we haven't been heard. And that's it. Thank you.
All right, thank you. All right, Eleanor and then Jane. Again, the question is this a new question regarding the citizens petition?
It's not, I'm so sorry. It's
Yeah,
not
okay.
a question. It's a comment, just kind of clarifying the math. Because it was a question that Jane raised. The 1696 is just a formula, 15% of our capacity, which was 11,305 units. And those have to be created over a minimum of, the website says 36 acres, it could be 50 acres. And I think you guys have mentioned this, it could be more dense or less dense. So with the 4 units or 16 units per acre, that would require an area that's 105 acres minimum. Like that's what the math says. But I just also wanted to point out, other towns have, and I'm not trying to be difficult. I just want to make sure we're thinking about this from an informed way and looking at it creatively and minimizing, potential new problems. But other towns have created sort of multiple districts. So maybe they're smaller areas that are, 4 units by right. And then there are other areas nearby that might be 20 units by right that are more dense. And if you go to this, and I just wanted to clarify, and again, please correct me if I'm misunderstanding the state rules here, but they don't discount development that's already occurred. So if you have an area where you already have buildings, according to their FAQ, you can draw a circle around it. And as long as you create a capacity that's by right could be done, it's the same thing. I mean, today we're creating a by right area that's in a place that's only, 1 and 2 and 3 unit housing. So it should really be no different. So I just wanted to put that out there. And, again, please correct me if I'm mistaken or I've gotten any of the facts wrong. But I would love to sort of condense the area even less than 105 acres, if at all possible. Thank you.
No, thank you. And I appreciate the comment and the question. And I'll invite other members of the board based on your understanding. The acreage versus density really is part of the process, and I think the way that has been discussed really has been about thinking thinking about what is the most sort of desirable height of buildings or sort of unit capacity. And so some choices were made that 35-foot height would be sort of the maximum. And that has a density limiting effect. And that's based on public comment and consideration. So that's where why some of the choices I think that were considered and vetted by the working group and then discussed with the planning board in prior discussions. I'm sorry, my phone is, my timer is wrong. That's sort of where those choices were made. So and that's why you're not seeing a 20 unit dense area versus a 10 or a 15. It really also does pertain to more of the specifics of the MBT3A law. And I know like the questions about why Foundry Street isn't part of the map. Those are we've discussed these, and those really pertain to, I think, very specific site conditions related to Foundry Street and why they were omitted. And again, to Jim's point also, that tends to water down the density calculation. When we've designated wanting to have at most 4 units on a lot and not going 35 feet. So trying to negotiate that, then Foundry Street doesn't really sit.
Mr. Chair, if I may, just to clarify from the mechanics of the law, one of the other things is that you have to have at least one district that represents 50% of the continuous area within a district, which is achieved in both maps that are being presented via the section of the maps to the west of North Ave, as well as the area between Albion and the lake, and then between North Ave and Main Street. In addition, you can, by the law, have multiple districts with multiple densities as referenced by Eleanor. However, there is a minimum They have to have 5 acres per any individual district. So it becomes, again, a map game that would have to be respected as you go through that element. But in terms of your basic understanding of the law, it's sound.
And sorry, if I can just clarify, I'm not just limiting it to Foundry Street. There's North Avenue, Main Street. The buildings that are going to go up there are going to be much larger anyway. They're happening today. So why, I would love to think creatively how we could include that, make it part of the district. Perhaps, and you can require mixed use. One can also require, affordability. So just throwing that out there, I think, again, there are different ways to approach this. And I don't think, you guys have chosen a way and it's thoughtful and I understand where you come from, but these more dense, larger buildings will happen anyway. So it would be nice to try to address that proactively. Thank you.
Thank you very much. Jane? And
Just a
again,
quick, easy question.
Sure.
Is there a place that the citizens map was put out? Like, did they have copies of that map for Article 18 that was placed out somewhere to pick up and look at?
I certainly believe it's available at Town Hall, and everything's on our website too.
So I can print it off the website?
Of course, yes. Yeah.
Thank you.
Yeah, no, sorry. I was going to try to pull up the website, but I'm not that good at Toggler. Thank you. I appreciate the question and the opportunity to clarify it.
No,
Thank you,
that's
Jane.
okay. I can pull it up.
Yeah.
Yeah, Theo, I just went to the planning board, our planning board website, excuse me. And yes, it's on the front page. It's the last one under the petitions, and I think it's a 6 or 7 page PDF. The last page has the map.
Great, thank you.
Thank you. Thanks, Bill. Debbie Fox. All right. Yes, please turn your camera on if possible, and name and street.
Hi, Debbie Fox, 12 Alyssa Drive, Wakefield. I think all of these meetings have given the impression that we only have 2 options. The working group plan or Mr. Dombrowski's plan. We absolutely positively have the option of just saying no to both plans. The town wastes a lot of money. The town can cut back. For the few $100,000 or maybe $1 million or $2 we get, it just isn't worth it for giving up the town. The choice comes down to, are we going to be a city or a town? That's what this decision is really making us. A decision or a town, when you see the number of people that will move in, the number of cars, the number of schools we'll need, the damage to the roads. There are 3 options. And I think too many people are locked in that there are there were 3 options, not 2. There are 2 options, and 3 options. Don't forget the 3rd one of voting no on both. Thank you.
Thank you, Ms. Fox. All right. Any other questions or comments from the planning board regarding the citizens petition? All right.
Theo, I have another question. So, Ed, you say you have some citizens that have put this up, and the majority of, and you say the community supports this, or I'm just trying to get how your map seems to have more support than another map. That's all.
Sure, happy to. So with respect to this map, for me, it's less about the map and more about the meeting the state minimum. And the overwhelming response that I received from residents that I've heard during these meetings, is that I've heard through the working group, any kind of forum where there's an opportunity. It was, let's comply with the law, but let's not exceed what the mandate is. Because people do, as you heard even this evening, listening to folks, people understandably do not like the idea that the state is coming in and taking control over decision-making that should be left at the municipal level. And so this is a representation and a response to the overwhelming input that I received and that this body and its various iterations via the working group, et cetera, have received relative to how to handle this issue of 40A3A. And specifically, the overwhelming response that I know that this board has heard and that I have heard, and that what I would venture to say is the town general consensus is we have to comply, but we don't have to do more than comply. The intention of this citizen petition is to comply with the law, but to not exceed the requirements of it. I respect what Ms. Fox had to say relative to not complying. I did mention that, and in fact, my last slide shows precisely that. We can violate the law by not complying. For the reasons I had stated, I don't think that that is the most reasonable approach for us to take. It is significant dollars, and by any indication, it's going to be more significant as time goes on. But equally, I think the exceeding the mandate by some 663 units is not representative of the general consensus of the residents of Wakefield. I think a balanced approach of understanding that there is a need that the state has forced upon us, and we have different options to meet that need. And the option that seems to be representative of the general consensus of the community is to meet the need but not exceed it. Seems like the right approach. And when that ended up not coming to bear ultimately, after the work of the working group, I took the opportunity to reach out to those who I knew were of similar concern, and inquired whether this is something that would make sense. And I mean, once the word was on the street that I was working on this, I can't tell you how many residents, many of whom I had never heard of before, had reached out and said, where do I sign? How can I sign? And even after it had been submitted, people were still reaching out to me with that. And I think that was really telling to me. It was showing that, people respected the process, but people also felt as if, we were saying this, we were expressing our concerns and raising valid reasons for why we wanted to not exceed the state mandate minimums, but notwithstanding, there was something that was suggested to the tune of 663 units. And to be clear, and I appreciate Ms. Axelrod's comments relative to being more strategic in terms of how we develop. I have for years been saying the middle Main Street, the corridor where we're doing the envision work, is a natural place for us to be able to have additional housing, mixed use. First floor retail or restaurants, hospitality, whatever the case might be, and then second, third, floor housing. That makes a lot of sense. I think we're underutilizing our downtown in that way. I've spoken with Mr. Chairman about this, and I do think that there are opportunities beyond this. I think we need to get beyond 3A, get this issue settled so that we can also focus on how we can identify particular areas that might be, more appropriate for additional housing stock creation. Maybe that means, for instance, studio or one-bedroom apartments. What does that in turn mean? It means less vehicles inherently, but it also means that we don't have the same sort of demands on the schools. I asked last night at the town council meeting of the school departments and the superintendent specifically about the issues of capacity, knowing that I was coming to this meeting tonight. There are very real concerns that the school department has and that residents have relative to capacity. I've often raised the fact that Walton is to capacity now. Others of our schools can't accommodate, the influx of additional students. So we have to be smart and strategic about this while also recognizing that we do have an affordability issue. I think the chairman makes a good point. Affordability just doesn't mean state subsidized housing. It means affordability that young couples can buy their first home in, right? How do we achieve that in Wakefield? I think there's a broader discussion to be had over time relative to this. I think the planning board is a part of this, as well as we go forward. And as I mentioned earlier, I think that the working group has really laid a lot of the groundwork of helping to identify some of the biggest challenges we have as a community. I don't, though, believe that this 3A mandate and expanding it to 663 additional units beyond what's required is the solution to that. It prohibits age-based housing to be included, and it specifically is not affordable housing, and it doesn't provide for that. And so we have opportunities. Ms. Axelrod mentioned that it's 20 units somewhere. Is there some place on Main Street where it would be appropriate to have a 20-unit building? Very likely. Above a really good restaurant and a couple of boutiques, even better. That's the sort of discussion we can be having. You're seeing that with the old Santander building, for example. We're seeing that becoming a mixed use and your discussion of the housing behind that. That makes sense. So there are opportunities for us to do that, but I think we have to be more strategic as a community because we know, where our pressure points are. And we can work through those and be able to develop really sound zoning and, for that matter, modifications that are allowed by the ZBA, who has done a fantastic job. Wakefield clearly is not developer unfriendly, but Wakefield needs to be friendly in a way that benefits our community in the most thoughtful and sustainable way, because to Ms. Fox's point, we don't want to become a city. We have a charm and character within our community that we need to try to preserve at all costs. So I think we need to think about how to do that. 40A isn't the panacea for all of this by any means. This is something, as I see it, a nuisance that we have to deal with. But then we can get to the real work. I know that the planning board hasn't necessarily looked at zoning in some years and overlay districts and the like. Perhaps that's a discussion to be had. We have a very robust ZBA that I think has improved a lot of projects that have come before it as a result. We have friendly 40Bs that have come into the mix just recently. I know Attorney McGrail brought one before the town council. It was a perfect friendly 40B. We need to have more of those sorts of discussions, certainly. And that's a community discussion to have. But I think we just need to get through this hurdle, get over it, so that we can have that more meaningful work and tailor zoning and tailor decision-making about where to have emphasis and focus on housing. And we also, again, have the Affordable Housing Trust, which can play a role in all of this. And I think that's a really unique and exciting opportunity for us going forward. But we have to be deliberate and thoughtful, and that's what I'm hearing from residents again and again.
All right, well, thank you. It's good that from the discussions you have that you got that people want a minimum zone, because when I've reviewed the notes and a lot of the meeting minutes and or the actual videos, and I've been at all of these, obviously, the overwhelming consensus I would get is that people don't want anything. But it's good that you have a number of people that want the minimum, and I appreciate that. That is good. You're getting a little offhand about affordability and things, but you know that we really can't do that with the type of land that Wakefield has available to us to have a by right zone to do that. So unfortunately, and the working group did look at that. We looked at other areas in town. It just didn't work out with the numbers. So I understand why we focus this around downtown. So
under 48, you're talking under 48 section 3A is what you're referring to, and I agree with that.
That's what we're talking about tonight. Yes, this
correct, but yeah,
not other proposals that are kind of outside the bounds of what we're dealing with tonight. So, all right, thank you.
No, thank you. It's an important question. Thank you.
Jim or Bill. And we've certainly had a lot of very robust discussion, and this is really helpful. Any other
Yeah, Mr.
questions?
Chair, I do have some
Please.
comments. I think, first of all, thank you, Mr. Dombrowski, for the citizens petition. Excuse me, I've been a little bit under the weather, but this I really admire the amount of work that the working group has put into this. I've learned a lot over the process as being part of the planning board. It's really complex, and each time the working group dug deeper into what the map could be, what other areas it could be, it just came back to the same calculations and mandates from the state as far as understanding what this law is. So it is really complex. I have pages and pages of notes from our meetings to understand like exactly what we can and can't do. And I know I feel more comfortable with a citizen's petition showing the minimum amount, as long as that map can be approved. And I know that's come up too. So Ed, thank you for going through and starting that process with Aaron Kokinda. What I do feel more in favor of is having the additional units because of how the half-mile radius from the station is laid out. And I happen to live within that half mile, especially on this map that you have on the citizens petition. I live in this map. So I understand the ramifications of it and what it means. What is complex and hard to understand, some of the comments that have been added tonight, especially from Eleanor Axelrod, it's been really helpful to understand other options, but I know the working group has looked at so many different pieces and parts of this. I would like to also say that with the additional units, and Ed, if you could go back 2 slides, I just have a question. I think it was 2 slides. Yeah, to this one here. Actually, slide number 5 that had the graphs, right? So the additional 663, when we look at the 39-40% more than what is beyond minimum, the amount of building that could happen, and this was like a light bulb for me when the working group shared this. I think this was back in the fall public forums, but we were looking at it and some of the questions that came up, and it helped me understand that with these extra units, it's actually helping us because each one of these lots that would need to go in front of the ZBA for a special permit to build beyond their current 1 family or 2 family to get to 3 or 4 families with the parking, with everything else. The dimensional requirements are still in play, and any unit that would need to go beyond those dimensional requirements would need to apply for a variance, which, if you don't know, and I think most people on the call do know, it's a much longer and difficult process. I don't know the odds to getting a variance, but I think it depends on what's being asked. That's something that really helped me understand more of what this map and what the different building units would. I think currently with the 2,359, I believe 25% of the lots noted on that map would be allowed to build as right. And correct me if I'm wrong, Mr. Chair, but this is some of the information that makes it so complex to understand. And we learned so much from the public input because every time public started to add comments, the working group went back and tried to rework how that would adjust the maps. So I just wanted to make those comments again, and thank you, Ed, for presenting this option.
Thank you, Bill. Rosemary, you have your hand raised, but you don't have any audio, unfortunately. Yeah. All right. Okay. All right. And I'm sorry, Rosemary, do you have a question? You're now muted again, but you do have your hand raised.
Can you hear me now?
Yes, ma'am.
Hello?
All right. I think you also have a cell phone there that's also dialed in. Can you mute your phone?
It's actually my iPad.
Yeah.
I've been trying to get in. Um, one
Yeah,
sec.
yeah. The feedback
For a
is,
lot of you, you live and breathe by Zoom. This is my first time, so I apologize for trying to get in and out, trying to set myself up.
glad you're
Um,
here. Thank you.
I have a question. Have any of you heard of Mike Keneally? Okay, Mike Keneally was part of the Baker administration and was involved with this from the beginning. And he did an interview on WBZ on March 27th. I don't know if any of you saw that. Okay, part of what he said, one of the goals of this MBTA is to flood the market with units to bring housing costs down. That, he said, was a goal of this. So what does that mean for those of us who have kept our houses, saw them increase in value, and now with this, to see the value potentially be decreased? I don't think that's been addressed at all. And that's a concern for the seniors in town who hung on, been there from the beginning. So that, just take it as a comment, because it seems crazy that this is a goal of our government, is for us to lose value in our homes. Okay. The other comment that I had is, has anyone talked to the building inspector at all about this?
Why do you like what?
Well, I asked that question because one of the slides said to include other groups, that have I can't see the slide to tell you. I think it's
So
slide 8.
Yeah, that you mean the comment about asking the input of
Municipal boards, official input from them. Has anybody talked to the building inspector? I guess not.
No,
So
I can speak
yeah, Aaron and Jim.
for which article, the one we're speaking about tonight, or MBTA communities in general, or the
Well,
planning board?
in general, because I mean, obviously, this is going to put a strain on what Mr. Mayo
Yes.
calls the small department.
Yes, we have had meetings. Jim Hogan has been there as well. With Steve Mayo, we've met with Benny DiCristoforo about 3 or 4 times, and I've had side meetings talking about it as well.
Okay, Erin, I mentioned to you at the senior center that, since October of 2022, that according to the building inspector, he hasn't had time to follow up on what he calls little things that are getting, not addressed. So how many other little things is he missing, and how many more will get missed that will affect the building in the town?
I can't speak for Mr. DiCristoforo.
I'm sorry, Erin, I can't hear you.
I'm sorry, I can't speak for Mr. DiCristoforo, so that would be a question. But I've talked to him about the MBTA communities just as a general, and he feels comfortable with what was put forward, but I can't speak to the little things. But I hear you.
But the little things start to add up, and things don't get checked and things don't get done. When a cease and desist order is issued in October of 2022 and he hasn't had time to follow up on it, there's a problem. Okay, and it's just concerning that with all this building going on, that things aren't going to get done right.
If I may just add, I think you raise a very important point. It's one that I have been raising in the context of development generally. And there was talk tonight of infrastructure, and I've raised that question regularly over my time on the town council, because we're talking about infrastructure. Obviously, we're talking about some of the physical infrastructure, the water line, water mains, and those sorts of issues, roads, traffic, right? But we're also talking about police, fire, emergency services. We're talking about our schools. All of those are meaningful considerations. And I think you raised another one, the building department. Our last census put us at just over 27,000 residents from about 25,000. So over a 10-year period, we had over 2,000 residents added to our community. That comes with consequences, right? There will be need for additional thought given to things like our schools, our fire facility, our number of firefighters, our fire apparatus, our pumpers. All of those sorts of things are really important considerations. So that's why when I was looking at this with the outreach that I engaged, that was a part of this process, it was clear that the idea of adding, under the working group's proposal, an additional 663 unit capacity was a bridge way too far. So while I recognize the need, although yes, it is technically optional, but in practical terms, it's handily not, the need to be in compliance with this, the idea of adding another 663 unit potential, to your point, Marianne, it's well taken, because that's another potential 663 more units that would require services. That
Well,
may
that
mean
doesn't
more.
even include all the other building that's going on in town.
I couldn't agree more. Again, I've said from the get-go, I very much dislike this section 3A. I think it's a terrible law. It's a one-size-fits-all. It doesn't belong in our community. But because of the way that our state government has structured this, they have, in essence, forced us into this position. So if we're going to be forced into the position, I'm just trying to mitigate the impact on us. And if mitigating the impact means going with the bare minimum or exceeding it by 663 unit capacity, I don't think the exceeding it by 663 unit capacity under this, as of right, 3A makes any practical sense. If there's additional housing demands that need to be met that we can meet, let's take them on a more strategic basis where we have local control over that decision making, rather than trying to shoehorn in to a law that doesn't work for our community to begin with, 663 more unit potential. That to me doesn't make a lot of practical sense, nor does it to the community that has reached out to me relative to this. They're not mutually exclusive. I know that Mr. Chairman feels strongly that we need to be able to figure out other ways in which we can find housing solutions. And I recognize that, and I support his passion with that. But we have to do it in a better way than under this law. This is a lousy law. And so why are we going to strip our town of more autonomy to expand housing under what's a lousy law, when we can do something better at the local level?
I hear everything. I've gone to several of the meetings, listened to several of the meetings, just never participated. So, what the thing is too, is nothing saying that the state won't change the rules as we go. They could keep adding things on that we have to do, because there's nothing saying ABC. It started out ABC, now it's DEF that we have to do. So it's like a never ending. Once they get their claws into it, they're just going to control everything that we do.
And the
Even
problem
if
is,
it's, no matter how many units it is, whether
if you
it's
look at
10
this map,
units
it goes to show the reach.
10,000
That's the state's reach with this 3A. Just on eastern part of the state here. Look at that. Those are all the communities that are affected. Even if you're a neighboring community to a community that has public transport, you're in a butter. So you get a coloring as well. So I understand what you're saying. I think we can all be on the same page that the state could have done a better job and had to have done a better job, should have done a better job, but they didn't do a better job. And so I think
the next one coming, the governor's already proposed another housing thing that's going to whack us too. So it's just going to be one thing right after the other.
All right.
Thank you.
Yep, I appreciate that. And Rosemary, thank you for attending our meetings and for getting your audio working. And yeah, no, really important that you've I'm grateful for your participation and grateful for you participating tonight.
Excuse me, Theo.
Yeah.
I think we've heard from all of the public that wants to have spoken. We're now into people speaking for the multiple times. So
Yep.
at this point, I'd like to make a motion to close the public hearing portion of this meeting.
Second.
All right. Thank you, Jim. Thank you, Matt. All right. So we have a motion to close this portion of the public hearing. All in favor? Jim Hogan,
Yes.
Matt Lowry,
Yes.
Bill Spalding,
Yes.
Kevin York,
Yes.
and myself, yes. And I say yes, and to say thank you to everyone who's participated over the length of this process. And the process really goes back for me to all the visioning and the master plan sessions, because those are also have been really informative ways of receiving public engagement. So and getting a lot of feedback from as many people across the town, residents, homeowners, and business owners. So our next item of business regarding the citizens petition is whether or not we have to take a vote to report either favorable action or unfavorable action regarding the citizens petition to be discussed at town meeting. So is there a motion one way or the other? I'm comfortable making a motion appreciative of all of the discussion we've heard and of the involvement of the working group that we recommend unfavorable action.
Mr. Chair, I would
Yeah.
second said motion.
All right, thank you for the second. Any discussion?
Yeah, I'm not gonna recommend favorable action on this just for the fact that some of the language in the text is inconsistent with actually applying this as a by right but by right zoning law without direction on how we are supposed to get public input from anyone who wants to speak on any project just for multi-housing. It wouldn't be for a two-family that someone is proposing, or someone who is in general residence zone that wanted to double their capacity and add another unit to it. But yet it basically says for if you go to 3 units or more, then the public has a right, or the public will basically have a right to speak at it. And then how we are supposed to address comments like that. I don't think when this goes to the state that will be something that they will allow. And I think they may want some changes on that. So I'm not convinced that there's a outpouring of the general public that prefers this to basically not having anything, which not having anything is, to me, not an option. So for that reason too, I am going to not recommend favorable action on this.
Thank you, Matt. Yeah, Jim.
So I will plan on voting to not have favorable action on this for a handful of reasons. The first being that while I understand and can agree that Section 3A as a law has some problems. I do think that the alternative map that's not in consideration tonight as part of this conversation that the working group developed and the planning board endorsed, I think it takes a challenging situation and does the best out of it and allows for thoughtful growth centered around our downtown business area, that if we do have new housing units delivered in town, is where it makes sense. There may be other changes that we would have made as part of the law if we were doing it outside of this 3A. However, I still hold that it represents thoughtful locating of new units in order to maintain as much the neighborhood character as possible. Some of the things that we heard today about the idea of having a 20 unit as of right, I don't think the community, if we presented that as an option, I think that that would have a very different, very negative reaction from the community if we were allowing 20 units as of right, based on how tall that building would have to be. And there's a lot of talk about local control. Those types of buildings are able to be developed in town, as everyone can see, but by special permit, which allows the ZBA to deny it if the project doesn't meet a minimum threshold in terms of providing public benefit. And yielding that control for larger scaled projects does not make sense, in my opinion. We looked at Greenwood, similar issues where based on the geometry of the lots that exist today, we would have to either increase the density to what we thought was not appropriate for a very predominantly single family housing district compared to where we were looking at. As a reminder, the zone, the other map that's being looked at, the whole map includes houses that are allowed 2 families as of right today. We're going from 2 to 4. And as everyone can appreciate, there's a mix of multifamilies and single families. You haven't seen a big rush over the last however long that 2 family has been allowed as of right to redevelop all those to 100%. I do want to take a step back, and I think people need to also understand this is not going to be a game changer in terms of either its impacts on affordability or on the neighborhood writ large. What we're talking about is even if you take all the units that exist today and you compare it to the maximum theoretical number of units, we all understand that that's not going to be 100% built out. If you were to take, just shooting from the hip, 10% of those units, you're talking about over, which from the literature I've read, over a 10-year period, between 5 and 10% is a reasonable expectation when you have new zoning go into place. But even if you did that, that is, anywhere between 60, 70 units that we're talking about over the, net additive over the course of, 5 or 10 years. The next time we're going to be looking at our 40B calculations is after the 2030 census. That of the 60 or 70 units, you got to have 10% of those be affordable. So you're talking about a net difference of 6 or 7 units of affordable units. So that's not something that is compelling to me. And I think that, Councilor Dombrowski's talked about the need for bringing in new housing and creating new options. Well, that's what this is intended to do. And I don't want people to lose sight of the fact that, yes, this is a small step, but it is a step towards increasing the amount of supply to help stop the super fast rise in housing prices, which does have some benefits for sure, but also impacts the ability for new people to come in and move to town. Because if you have your houses appreciating as fast as they have been, it just creates a gigantic barrier of entry. So as a Commonwealth, unless we're comfortable with the current trends where we're seeing more and more of our population leave the state, net migration out of Massachusetts has been positive for the past couple of years. So unless we're comfortable with that as a continued trend because people are leaving the state because of lack of affordability, then I think that we need to seriously consider taking steps even beyond what we're talking about tonight of how do we address our housing supply as a general issue. This is a very modest step in general. And if these are the types of modest steps that we can't take as a community, then I fear that some of these trends that we've seen in terms of our impacting our competitiveness, which is something the current governor has said multiple times is a worry from a business perspective, I think those trends are going to continue. I also remind everyone that this is something that this law was passed by a Republican governor and is being enforced vigorously by a Democratic governor. So there are obviously, it's not our traditional left-right split, and there are people who are either Republicans or Democrats who are in favor of this, and obviously other ways. But I think we should keep in mind that this is what the district that's been proposed is the best for our community. And that's why I'm going to vote to not recommend favorable action on this citizen petition. And I'll plan on proposing favorable action for the one that was developed by the working group and endorsed by the planning board.
Thank you very much, Jim. Yeah, Bill.
I will also vote to not recommend favorable action for some of the same reasons Jim and Matt have pointed out. I do feel strongly that we do need housing, and the understanding that if we can smartly add these units to help us control, regardless of what's been said tonight, we will gain more control by adding this overlay district and allowing us and the ZBA to review by special permit and by variance if needed, any of these units, any of these lots that will be developed beyond their current units. So that's how I feel about it. Thank you.
Thank you, Bill.
I concur with what Matt, Jim, and Bill have expressed. In particular, Jim laid out a pretty strong case for why the subcommittee made the recommendations that it made. I think that it's a smart, proactive way to address a situation that was given to us by the state and to make it fit our community best as we can. So I will be voting to not support favorable action on this.
Thank you very much, Kevin. And I too will be voting to recommend not favorable action on the citizens petition. And Jim said it very eloquently. And the only thing I would add is through all of these discussions, what has impressed me the most is the amount of citizens engagement and the underlying support for more housing for families, more housing for seniors, a wider diversity of our housing stock, which does mean adding more opportunities for multifamily housing of different sizes, and but also concerns that are common around how to better address our traffic enforcement, and ultimately how we support our local economy, how we support downtown, and how we maintain a vibrant and inclusive and welcoming community. And I think this proposal falls short, and not just for the reasons that Matt said from a technical perspective, but I also think the map is insufficient, and should any amendments or other things like that, I think this doesn't position Wakefield well. So with that, I again thank everyone, and I thank Councillor Dombrowski for presenting the petition tonight. And so we'll take a roll call vote. So the motion for unfavorable action has been made and seconded, and we'll take a vote. Jim Hogan?
Yes.
Kevin York?
Yes.
Bill Spalding?
Yes.
Matt Lowry?
Yes, on an unfavorable vote, yes.
Yes, and myself, Theo Knoll, I'd recommend unfavorable action. So thank you all, and thank you everyone for the discussion tonight. Our next item of business on our agenda is to any final discussion on the MBTA Communities Overlay District as previously presented from the working group and reviewed by the planning board. So we chose not to take a vote whether to recommend favorable action or not on this, so that we could have a full and complete discussion of the citizens petition. So with that, is there a motion? Yeah, Jim.
I would like to make a motion to take favorable action on the MBTA 3A overlay district as referred by the planning board to the town council.
I'll second that.
Thank you, Matt. All right. Any discussion?
I'll start. I was on the working group that worked on this proposal, and a lot of the comments that came up tonight about why didn't we try other areas, why didn't we try different districts, those were all addressed. As Jim has pointed out, this has been a long process. We have looked at a lot of different issues. Jim personally has put a lot of time into this, and I appreciate that. Working with Erin, a lot of extra time went in. There was a lot of work that went into this. It wasn't done easily. I do take offense that people say that we did not listen to the public at all. We did have a very vocal contingent of people that, again, basically did not want anything. And I really do not get the sense that people wanted as small as possible either. They basically just didn't want anything, which is not really an option. The working group looked at this as, this is a mandate from the state that we need to come up with a multi-family housing zone. And with that, what can we do in Wakefield to help make it work best for our town? This was not a one-size-fits-all as was pushed out. Every town had some parameters that they had to work with, but they were able to tailor this as best as they wanted to fit their local bylaws, to write something that would work for them. And we did that, I truly believe, by making sure that this included downtown. We have an issue with downtown about traffic, basically traffic getting into stores downtown. And that does not mean the traffic has to come solely by someone driving down there. So getting more people downtown where the stores are was and is a priority in order to save and revitalize downtown. This is not going to fix the problem, but it's a small step in the right direction. I think moving a zone further away from downtown towards around the commuter rail station was not the best. I get parking issues, but we're already addressing parking issues within this zone, and any new parking regulations or parking issues can be addressed. As has been pointed out, this is not going to be built out 100%. The economics of doing this just don't work for every single site. It is a step in the right direction, and I think what we have proposed is the best that we can do. And that is including having a district that is a little bit larger than is required. It is not, as I've heard, grossly too large or, excessive. This gives us options to make sure that we work on revitalizing downtown, because frankly, nothing has been done to add any new zoning changes in town, except for going through the ZBA process of special permits. So that is why I am recommending favorable action on this. Thank you.
Thank you, Matt. Yes, Jim.
I like to add that, again, I don't think that this is going to be the silver bullet that's going to solve all of downtown's problems or the housing crunch or any of those types of things. However, I do, like Matt, affirmatively say that I think that this district that's been developed is a good district, regardless of the state law, and provides a step in the right direction to help locate residents near our downtown businesses, lowers the barrier of entry for developments that aren't materially different than the existing neighborhood character by maintaining that 35-foot height, not allowing larger developments on the side streets, locating any new housing that's delivered within town by our existing transit, which includes both the commuter rail station, but also the bus route along Main Street. So over time, the thought being that people who live downtown or in the areas will utilize those options and mitigate the number of cars. I think we all understand that that's not going to eliminate the number of cars, but it's just trying to minimize them as much as practically possible if we're delivering additional housing stock. In addition, this district, where the density is going from 2 to 4 units, where we have 2 units are allowed as a right in all these locations. So to some of the earlier points, I would not expect every one of these to be built up to a 4-unit. The Chestnut Street property that we've been talking about ad nauseum, that went up to a 3 units, for example. And the other thing is that by making lower impact developments easier, it makes it so higher impact developments are not as enticing to developers. As everyone can understand, the developers are looking to minimize their cost and uncertainty. And if we make it so a 4-unit building is as of right, it may make it so something larger and more impactful, like a 10-unit. If you don't need to go for a special permit for a 4-unit, it may make it so that math works out better than undertaking the additional risk to go up with something more impactful. So the thought is that it's a increase in density, but it's not by increasing it by large amounts and by making it so lower impact developments are easier to deliver. You may see more of them and therefore have the total number of housing units go up, but not in a way that is super impactful. Obviously, this is only one component of our housing delivery strategy, and there's other sections in the zoning that are there and are appropriate for larger scale developments that can be reviewed separate and apart from this. But I do want to emphasize, based on all the different reviews that were conducted as part of the working group and all the conversations between members of the planning board and members of town staff, I do think that this represents the best map possible for the town. And I wouldn't be saying that and sitting here and advocating and going through all these meetings if I didn't truly feel that way. So on the basis of that, I will be voting for favorable action for the MBTA overlay district that was presented to the town council by the planning board.
Thank you very much, Jim. Yeah, Bill.
I have 2 quick points, and I'll just start by saying I will be voting for favorable action for this plan. And I thank the work. I thank the working group for all the work and all of I've learned through this process. I do remember back to 2014, 2015, when our planning board developed an overlay district for mixed use in the downtown area. And I had to pull up the map just to see exactly how the two work together. And it is interesting, like thinking of Main Street and North Ave and how we identified those areas to be the mixed use area. And I feel this map that's been developed and that we've been reviewing for, I can't remember how long now, but it seems like it's been over a year since I've seen this, a couple versions of the map. And I do really appreciate the input from the public and understanding that over the forums, we had about 12 or 15 people that were speaking against just building in general, to Matt's point. And that's something that's pretty common. And to talk about the emotional side of it, I think everybody on this board, we're all on the board for different reasons. And I know what drew me to the board was safe streets to school, safe walking routes, understanding how to get around town without having to depend on a car. It's been a lot to understand the complexity of 3A. And Matt made a point that just really made me think about it in a different way. The state could have gone the 40B route and said, okay, no, there's a whole different process that people would go through. But no, we're able to, as a town, to really create this map, explain what we want, and then have it. And whether our board votes favorable or non-favorable action for any of this, it's going to go to town meeting. And participation wise, how many people, and this is the emotional side of it, it really sucks and hurts that there's only so many people that go to these meetings and speak up about it. And everybody can have their excuse and everybody has a busy life, but I don't know. I don't know many people that are busier than the people that are on this board. And again, I really appreciate the time, and I'm looking forward to town meeting to see what the public has to say. But again, I vote in favorable action of the current plan. Thank you.
Thank you, Bill.
The subcommittee put in a lot of time and effort and thought into developing this map and this proposed bylaw. And in that presentation that Jim has gone through several times for our public hearings, it clearly identifies that we have a housing shortage in Wakefield. And I feel like the plan that they put together and the map that the subcommittee put together starts to take steps to try and address that problem in the long term. Like everyone else has said, it's not going to change it overnight. It's not going to make a significant impact, but it starts to, and that's what we need to start doing. And I think we need to do less in this community, complaining about the problems that we have, and then not voting in ways that address those problems, which it seems to be a consistent thing that we do. So this is a way that starts to address a number of problems that we're facing, from outage to downtown foot traffic to just overall support of businesses downtown. So for those multitude of reasons, I will be supporting favorable action.
Thank you, Kevin. The only thing I want to add, I will be supporting favorable action, and I can't thank all the members of the working group and town staff and everyone who's devoted so much time, energy, and intellect to think this through. I'm voting favorable action for all the reasons stated, but also because we're taking a proactive step to adopt a local tool to meet local needs. And I think this is a really good representation of what Wakefield can do. But also, I'm excited for all the future opportunities, given all of the interest and commitment that's been expressed by everyone throughout all these discussions. The strong need for family housing, the strong need for senior housing, the strong need to come up with new creative ways to address some of our traffic concerns. All of this really speaks to lots more positive opportunities for us to work together to make the very constructive changes so that Wakefield continues to be a welcoming, inclusive, and very livable community. So that's why I'll be voting favorable action. So with that said, we can take our roll call vote, having a motion and a second. All in favor, Jim Hogan,
Yes.
Kevin York,
Yes.
Matt Lowry,
Yes.
Bill Spalding,
Yes.
and myself, yes, Theo Knoll. And again, thank you everyone for such a a thoughtful and considerate process. Item 5 on our agenda is discussion item regarding the marijuana establishments overlay district. It came to our attention, and I think, Kevin, this may have come up, or it did come up in the bylaw review committee. Do you want to speak to it, or would you like me to give it a quick summary?
Sure, I can, and I see Attorney McCarthy's on as well, and he chime in. He was in that meeting. So essentially, when we were debating the way that we were defining distance from a educational institution, we were recommending originally as a planning board that this article follow the current revisions to the current bylaws based on what the bylaw review committee is recommending based on the feedback from Attorney Bobrowski. Attorney Bobrowski and Attorney McCarthy realized that the language that was originally in our updated revisions is not consistent with what the state is recommending based that language should be. So what we discussed on that call was actually reverting back to the original language that Attorney McCarthy had in the proposal, because that actually is in line with what the current state recommendations are. And Attorney McCarthy, feel free to chime in if I missed anything.
That's exactly right. The hour is late, but if I could share my screen, I could just show you
Sure.
illustration one. So
you're not sharing yet.
Yeah, thank you. Is that sharing? Okay. Do you see that?
Started. Not yet. There we go.
Okay, so this is what was proposed in the original in the citizen petition, and essentially where kind of the rubber meets the road is right here where it says distances shall be measured. So this mirrors the CMR, where the 500-foot distance essentially gets measured from the center point of the entranceway to a marijuana establishment to the center of the entranceway of a school. And then there's language about if there's an impassable barrier, then you go on a traveled way. The let's see if I can do this without the this is the can you see this, the change on the screen?
Yes, we can.
So this is the way the bylaw committee draft, which had been dated 12/31, read. So the 500 feet would have been measured right here from basically building to building, from the nearest point in a straight line from a building to a building. So as we discussed at the at your meeting, our meeting, we had no problem. My client, the citizen petition and the petitioners had no problem with this, but Attorney Bobrowski pointed out that that was not a good idea, that would not be approved by the state. He cited a recent case that was basically along the same lines, which said you can't do it. You need to follow the CMR. So this is the CMR, and it shows you, and it does mirror the proposed bylaw does mirror this. Sorry, it's a big file, so it takes time to read, but it's 500 feet. It's the exact same language. It's center point of entranceway to center point of entranceway. If there's an impassable barrier, then you measure according to the travel path, which is right in here. So essentially, the idea is now to just leave it the way it was originally proposed. Does mirror the CMR. That's where I get the language. And Attorney Bobrowski said that the language in the bylaw committee draft is not enforceable. It wouldn't be upheld. And my understanding is the bylaw committee will have to revert to the CMR language, which is consistent with what was proposed in the citizen petition that this board considered. And where the board took a vote at the last meeting to condition your favorable recommendation on this to the adoption of the bylaw committee draft, obviously I thought it prudent and necessary to come back to you to report that, number one, and to number two, ask you to essentially allow or endorse or vote favorably on the on the original 500-foot buffer language. That's it.
Thank you. Yeah, and I'm looking at the minutes from the last meeting. So to me, this means I think we need to have a second. We need to revote, have a motion to reconsider our recommendation of favorable action and remove the condition that we were suggesting. Is that appropriate procedurally? Or do we not need to?
Theo, I think that would be appropriate to make sure we're all on the same page.
Okay.
So just to refresh my memory, was this the only condition that we had? I know there was one about removing cultivation and processing, but that was up to. That's
If
still
I
in
may.
the bylaw,
Yeah,
correct?
no, I'll jump in. We made two motions to recommend favorable action. The first one was to reduce favorable action to reduce the map to a single lot. And then the second motion for favorable action was based on this conditional changing the language regarding the buffer.
All right, and
So
that was the only text amendment that we were considering, correct?
Yeah, yes, there was
Yeah.
discussion, if I may, there was discussion on the table, Matt, but the outcome was to leave it alone. So that the board, if someone wanted to expand the district in a different area, you wouldn't have to rewrite the bylaw, that the different uses could be considered at that.
All right.
Rather than have a different table for each area.
All right, thank you for that. I appreciate it.
So, right. So our first motion to recommend favorable action based on a reduced map still stands, and we are reconsidering our second motion from last time. So
Theo, I will make a motion to recommend favorable action on the text of the bylaw as presented with no conditions.
all right,
Second.
thank you. All right, thank you. Thank you, Bill. Any additional discussion?
No.
All right. All in favor? Jim Hogan,
Yes.
Kevin York,
Yes.
Matt Lowry,
Yes.
Bill Spalding,
Yes.
and myself, Theo Knoll, yes. All right, so very good. All right. And Kevin and Attorney McCarthy, thank you very much for circling back.
Thank you all. Have a good night.
Yeah, you as well. Item 6, items not anticipated by the chair. Other than my gratitude, I don't have anything. Does anyone have anything else to bring up? Yeah, Bill.
Quick question. We had talked in a previous meeting about possibly adding another meeting. Was that something that still needs to happen for, I believe, to look at a calendar? I think it was the 30th. Is that correct?
So yeah, we discussed that. We are not going to add a meeting on April 30th.
Okay.
There's a potential that it conflicts with town meeting, but also the sole purpose of that was so that we could elect a new chair and vice chair. We'll do that.
That's right.
We'll do that at the May 12th.
Just wanted to make sure. I know I had my computer went through an update when I was just trying to get on it. I can't believe it took like 15 minutes for it to like restart. So anyway, yeah, I was a couple minutes late for the meeting, so I apologize.
No worries. No, I appreciate it. So, anything else from other members? Samantha? Yeah.
I just wanted to give a quick update to let everybody know that the Housing Production Plan RFP is getting close to release. Actually, I've been working with Aaron and Steve, the town administrator, and it's getting reviewed by Tom Mullen, and then we'll be working towards getting some dates. I just wanted to give you a heads up that I've been working hard on getting that done. So hopefully we can make some progress and address affordable housing in the area.
Yeah, that's terrific.
And it's
Another,
perfect timing with our Affordable Housing Trust now getting up and running, so it's all
Yeah.
just coming together.
well
So
said.
thanks, Sam.
Yeah, woohoo! All right. Well, not seeing any other items for discussion, I will accept a motion for adjournment.
I think Jim should make this.
Motion to adjourn.
Second,
All right. You beat us all. All right. All in favor? Matt,
Yes.
Bill,
yes.
Kevin,
Yes.
myself, yes, and Jim.
Yes.
All right. Again, thank you everyone for going the distance tonight and every night and all the meetings in between. So I appreciate everyone's commitment to working together and for the town. All right.